Silence. Yes. Yes. Monday. Freezing of bank account. They filed any counter affidavit? Next week. Yes. Not conducting? What inquiry?
Police inquiry, not taking against the FIR.
Some of this. Yes. Madam? Now, all the rowdy cases will be considered only after vacation, not now. After elections only, not now. I am aware about the rowdy sheets matters being reserved. See, madam, I am saying that I will pronounce the orders only after the elections. Registration?
The vehicle is expired now. I'm unable to apply the vehicle for the tax file and a file and ID for exemption of the water system. Very big.
Next week. 2021. What is urgency now? No, what is the urgency now? So she is suffering since last 2 years. Then what is urgency now? She has to enter into, go before family court, file appropriate application under the Domestic Violations Act. Next week. Contempt, there is no urgency. Contempt is between court and the contemnor. What is your role as far as contempt is concerned? Yes, no urgency. Yes. Matter?
Actually, there is a rowdy sheet matter.
No, I am not interfering. Rowdy sheet matters are concerned. Wait.
Much of this year, and now they are continuously for bind over.
They are entitled under Chapter 8 of the Criminal Procedure Code to bind.
There is no cause.
See, even after removal of the rowdy sheet also, still this for the purpose of conducting peaceful elections, they are entitled to maintain surveillance against any person. Simple because, see, even if there is no rowdy sheet also, still they are entitled to exercise their powers under Chapter 8 of the Criminal Procedure Code. For a moment, forget about there is no rowdy sheet or history sheet opened earlier, and there is no history about the petitioners being involved in and causing a public disturbance. Still they are entitled. What is wrong in it? No urgency. No urgency. No urgency. I am saying that no urgency. Yes. You want to withdraw the petition? Monday. Yes. All the rest.
Instruction and the number please to allow
So many requests by the arts.
No urgency. Yes. No urgency. If it reaches, it reaches. Otherwise, you wait for till your turn comes for reaching.
Already the electric post was done.
It is listed already in the least cause list. You wait for the, when it reaches, you will argue the matter.
Page number 1, item number 120, page number 2, item number 23, page number 3, item number 26, page number 4, item number 34.
Item 30. Yes. You can't wait for till the matter being reached. For it is listed as withdrawal matter. Why urgency to make a mention at mentioning time at 10:30? You can't wait when the matter being reaches. You wait till it reaches, you make a mention. Yes. Item? Yes. Have you informed other side? Yes, at the request of the learned counsel for the petitioner. Release this case on 8/12. Yes. Yes. It is a contempt case. We will examine whether any contempt is there or not. What is necessary of filing of any reply? What is necessary of filing of any reply in a contempt is concerned? I will examine whether if there is any violation or not. When the matter was examined, you make a mention. When it is really requires for granting an adjournment for filing of reply, I will consider. Yes. Yes.
Respondent filed this order. He filed one more petition. He filed English petition.
You contest the implicit petition. I will close the contempt case.
2 weeks.
No. I will examine whether any contempt is there or not. If there is no contempt, I will close the contempt with an observation that pursue the remedies in the writ petition. You wait till the matter reaches. Yes.
Page number 5, item number 51 to 69. Page number 6, item number 70 to 89.
My lord, item number 78, my lord.
Item number.
78, requesting for time, my lord.
Wait. Yes.
Milord, item number 76.
Item number.
76, Milord.
You want 1 week time? That is not a ground for asking time when your senior is. Yes, at the request of the learned counsel for the petitioner, list this case on 8/12. Yes.
77.
Yes. We will examine whether it is really requires any filing of reply or not. Therefore, I am saying that whether if it is really required for filing of any reply, I will consider. You are not following this the suggestion being given by the court. We will examine whether really it requires any reply. I will consider for granting of time. Yes.
Page number 7, item number 92, 110.
Yes.
My lord,
Thank-
item 76, my lord.
Yes.
My lord, requesting time for 2 weeks, my lord.
Why?
My lord, due to senior ill health, my lord, requesting for
Senior?
2 weeks.
Senior in health.
Yeah, my lord.
Who is appearing the senior counsel?
M. Venkateswamy, my lord.
M. Venkateswamy, senior counsel.
My senior counsel, my lord.
Yes, at the request of the learned counsel for the petitioner, list this case on 8/12.
Deeply obliged.
Yes.
Page number 7, item number 92, 110. Page number 8, item number
90? Yes. Police officers? What is that you want?
Police officer attack is the complete attack is the
So today, what is that you want? ఏం కావాలి ఈ రోజు మీకు? Asking for 230. No, let it be there in the list. Yes.
item number 1.
Wait, please, Your Lordship.
Yes.
But this is a application under Section 9 in an international commercial arbitration. The
Yes.
arbitration clause is at 35. Respondent 2, my lord, is a party outside India, therefore it's an international commercial arbitration.
Yes.
The settlement agreement is at page 22, in terms of which respondents 1 and 2 owe a sum of 9.5 crores.
Yes.
And this settlement agreement was entered into on the 10th of February 2022.
Yes.
And the amount was to be paid within a period of 45 days. It has been more than 1.5 years. And my lord, there is complete depletion of assets of the first respondent, as is evident from the balance sheet, which your lordships will find, my lord, in the financial statements at page number 201.
Yes.
My lord, that's the reason, my lord, if your lordship can kindly
There is the clause in which page there is a clause of agreement with regard to arbitration.
Yes, your lordship. That is at page number 35.
Yes, read the relevant column clause.
Yes, my lord. Page 35, your lordship, kindly see.
Yes.
Dispute resolution. All disputes relating to the validity, interpretation, construction, performance, and enforcement of this agreement shall be first tried to be settled amicably between the parties. And failure to settle such dispute within 30 days of the reference of such dispute, the same shall be referred to arbitration. Such arbitration will be governed by the Indian Arbitration Act, Arbitration and Conciliation Act 1996.
Yes.
But it is to be referred to 3-member arbitral panel. But the settlement agreement, my lord, if your lordship please goes back to page number 28 for a minute.
Yes.
My lord, the parties to the settlement agreement would be, my lord, the third party, that is Pegasus Global Private Limited, is a Singapore-based company. And your lordship is kindly aware, the moment there is an international party, it becomes an international commercial arbitration.
Yes.
And Section 9 jurisdiction is conferred on your lordship.
Yes.
My lord, the prayer I'm seeking at this particular point of time, my lord, although there are several prayers, your lordship may kindly consider granting me only prayer B. That is so that, my lord, non-alienation of assets, because the assets are already so depleted. Whatever remains, my lord, if they alienate, then the petitioner would be getting nothing.
Notice before admission. There shall be interim stay of status quo in all respects with regard to the. See, with regard to us.
Assets of the respondents, my lord, may kindly say.
With regard to assets of the respondent number 1. Pending dispute. The petitioner counsel is permitted to take out personal notice and file proof of service. List this case on 15/12/2023.
Great to you.
Item number 2, Mr. Pillar. First time.
What is the matter? What is the order?
Going on the land, on the land.
Notice before admission. List this case on 8/12.
Item number 3, Mr. TSHC. Petition challenging opening of rowdy sheet against by order dated 18 July 2023. The petitioner was directed to submit a presentation in 3 weeks. The Assistant Commissioner of Police was directed to dispose of the same in accordance with the police line order 6.6 and the parameters laid down with some. I made a representation on 27/7/2023. It was received on 3/8/2020. Even after 3 months, no decision is taken.
Yes, notice before admission. List this case on 8/12.
Item number 4, authorization.
Yes.
The petitioner is neither dependent in the suit merit. The plaintiff obtains after conditional attack.
Read the impugned order of. Read the impugned order. Yes.
Order below is seeking clarification of the order. The Honorable Court will directed
21/9/2023.
last kind is in page number 19.
Yes.
The main, yeah, let's talk about the
Page number?
Page number 19.
Yes.
And the page number 4, the petitioner demanding to obtain the land valuation development of planning, one month of punishing security, third party security, but trial court dismissed the same. The general process of actually in view of the answer allowed with CRP, directing the
Granting time
yes.
of 1 month to furnish the security. Have you furnished the security?
Furnish security is not third party, but of his personal
No,
property.
there was a direction to furnish the third party security.
True, but
Have you completed that order?
the person earlier who-
Have you completed that order?
Yes, sir, you have to immediately.
No, you have not furnished third party order. Read the now impugned order, page 4. Read the page 4.
Yes. Yes, the-
Read the order, mister.
Yes. Implement order is presented. Page number 4.
Yes.
Page number 4, the court below says that the contentions of the both parties is recorded by the court below and the plaintiff will defend counsel present. Plaintiff counsel argues that answer for direct defendant to the third party security, but not self security. On the other hand, the defendant argues that when the court has furnished security showing his properties when nobody are there to furnish security, third party security, then the object of furnishing security would be defeated. However,
See, if at all, if you need any clarification, you have to file an appropriate application seeking clarification of the CRP number 2201 of 2023, not by filing a separate application. What is wrong in it, the trial court order? What is wrong in trial court order? How can trial court will travel behind the scope of the orders being? No, you have to file an appropriate application seeking clarification. Have you filed an application seeking clarification now?
That's what before the sound of the they have to come. So they
Have you filed a clarification petition?
no, not.
You have to file a clarification petition seeking clarification of the orders passed by this court in CRP.
We have to put in there to furnish third party security. Yes.
We should seek the
But
clarification.
38 group 5 says here, that does not say.
You are not
anything about-
following.
Yes.
See, whatever merits you are having, if unless and until the orders being clarified,
Yes.
earlier passed by this order, I am not supposed to pass any orders now.
Seeking clarification.
Yes.
That it is clear. These third party.
You file an appropriate application expressing the difficulties for furnishing of the third party security, saying that these are the difficulties I am facing. In place of third party securities, I may be permitted to furnish a personal securities that can be modified. If done, once it is modified, otherwise how can the trial court will accept? It is binding on the trial court.
Clarification of the order is here. Yeah. Lordship was to do that.
I am not choosing. The law says that. Law says like that. How can you file this revision? This revision is not maintainable.
Seeking for clarification.
I will dismiss revision. You go before Supreme Court. Yes, not.
I will withdraw the liberty to.
That is the proper way. You file a clarification first, then file a memo before the trial court saying that seeking the order of the person, third party security, wherein there was a specific direction in revision, earlier revision. I filed a clarification petition. You kindly defer the matter, then get a clarification, and once it is listed before me, we will consider the same. You are not following. There is a finding being recorded. Whether you may be right according to law. You may be right according to law, but I don't have any power to clarify the orders being passed by the earlier court in a revision. And the trial court has rightly relied upon the earlier court order, and the trial court has dismissed. Trial court is also not having any power to modify. It amounts to modification. It amounts to modification of the earlier order. The Land Council for the petitioner seeks permission to withdraw the petition, withdraw the revision with the liberty to avail the remedies as available in law. With the liberty, this revision is dismissed as withdrawn. Yes. First you file the clarification, then file a memo there, and after disposal you file an application. That's all. Yes. What is the offense involved? Section? What is the vehicle? Two-wheeler. Disposed of.
Item number 6, Mr. Mohammed.
May I please, my lord?
Yes.
Release of vehicle, my lord. Section 34A, my lord.
What is the vehicle?
Vehicle Maruti Eco, my lord. Eco van.
Model?
2022, my lord.
It's 1 lakh.
My lord, 50,000, my lord. Is it?
75 years. Yes.
Oblige.
Item number 7.
Yes. Yes.
The party has highlighted. That will be allowed. Notice directed.
Yes. Petitioner is permitted to take out personal notice in IA number. IA number? IA number 2. Direction. Direction. There is no implied petition. What is this IA number 2? What is this IA number 1?
Complete the investigation in the reasonable time, the direction, so that because after the incident also. some was-
See, where is the implicit application?
Application I filed on the very.
Where is that implicit application now? USR number is not the concern for the court.
Yes, also.
Whether IA is numbered.
Yes. Number according to.
Yes, list this. The office is, the register is directed to verify the IA file by the USR number.
And the place.
List this petition. After 2 weeks, that is 24/11/2020. Yes.
Item number 8.
IA ne లేదు. Yes, what do you say? What is the matter? Why you are summoning the petitioner to the police station?
In the civil dispute between the unofficial respondents.
Where?
Was doing the petitioner take a small amount from the unofficial respondents. She declared it in the loan amount 52 crores. They closed the business mirror. Same time, the police came to the petitioner house mirror, taken to the police station.
How it amounts to civil dispute? You have cheated the other respondents. Having borrowed the money, you are not paying in time.
The remedy for civil court will be done, cheated mirror. Taken loan mirror, I clearly stated in my affidavit mirror.
Yes, read the relevant portion of affidavit.
There are 8 mirror.
Yes.
The respective affidavit, the unofficial respondent has the choice of approaching the complaint civil court or resolving the civil dispute. But however, the respondent for and by before directing the response to aware people to the process by directing the complaint civil court. For obvious reason, forcing me to come to settle in the police station on the threat of escaping against the past criminal cases.
What is the document you have executed in pursuance of obtaining the loan?
Put document. Put document.
Yes. The petitioner is permitted to take out personal notice to the respondent 6 and 7, 6 to 13. List this case on 1/12/2023. Interim order granted earlier is extended. Till then.
Item number 9 is statute paper.
Yes.
Before your lordship is the result of Ballari Sir Karnataka. Partnership business is going on at Ballari, but it will be established at Ballari. There are disputes among the parties. The purpose of the dispute, one of the partners compared CCS has was militant brought a case against other partners. The petition before your lordship is the employee of that partnership. And the monthly salary of 50,000 people is to cover the fleet of the vehicles which are engaged in the transport as a. Now,
Now, in this case, my lord, I was called by the I1 my lord, expert number 3 to the TSHC my lord, and I have explained everything about the rest and the role of petition. Instead of that, my lord, I am being attended by him and in that I indicated this.
The petitioner is
also please.
The petitioner is permitted to take out personal notice to the respondent 4 and 5 and file proof of service. List this case on 112.
But I may be the other accused may not grant 41 notice may not be given table.
I will dispose if that is the case. Yes. The case of the petitioner is. You are saying that the fourth respondent to defreeze the bank account of the petitioner.
After filing of the petition application, my lord, I was made informed that I was made as A5 in this case.
Both sending the notice of Bala to close the account. And then notice on 21/10/2023, and they are already closing 5/10/2023.
They received that Bala, my lord, they are filing case at Hyderabad.
The case of the petitioner is that he is working in MNR Logistics, fifth respondent company, as vehicle in charge, on a monthly salary basis. At whose instance complaint has been registered against the fifth respondent? The case of the petitioner is that the instance of the fifth respondent has largely a complaint. The same was registered as a crime. Same was registered in a, same was a fifth respondent largely a complaint against. Same was registered as crime number 285 of 2023, public EOWT-V, public CCS, DD, public 2023, dated 21/10/2023. The case of the petitioner is the respondent police, the third respondent, without issuing any notice as required under Section 41A of the CRPC, is issuing summoning the petitioner to the police station and confining hours to the petitioner. The grievance of the petitioner is that the respondents are the learned counsel for the petitioner vehemently contended. The respondent police is not having any power or authority of the petitioner. Yes.
In fact, two FIRs are filed with the respondent. And the sixth respondent is police, they are interfering the other.
Yes, what do you say? Yes, ready.
petitioner lodged a complaint against the
Petitioner lodged a complaint. You have acted upon complaint of the petitioner. Then why you are interfering with the petitioner's affairs? Yes, friend. The petitioner claims to have purchased 2 acres of agriculture land in survey number 250. Yes, what do you say? Says read your complaint. Page number 11. Is it your case that TCK Singh has forcibly taken your vehicle?
The vehicle belongs to myself. The person from whom he has taken is my husband. Up to me and two others suppose I have taken only the bullet. I went to PS.
Hmm.
And the vehicle has been brought to the police station. But either I have been complained to just compromise and issue to the
If the vehicle has been brought to the police station,
Yes,
if you register a case, then hand over the vehicle to the competent court. They will file an application under section 451 and read with 450. Why you are keeping vehicle with you? Jidmata police station, why it is required for the inspection such a time? It is a local police station. No. Get instructions by 250. Yes. It's a bullet vehicle. It is there in the police station. There is no safe to the vehicle. Yes.
Police insisting them to come to police station and settle the issue with the.
Where is the lease date?
Page number 13.
It is unregistered document. How it amounts to lease? Lease for a day also compulsory required registrable document under the province of.
Just preparing possibly society or particular community.
This is between. Whatever may be, when you are relying upon the lease deed, you have to establish that the lease being registered one. Who is interfering now with your question? Who is interfering with your question?
Respond to police.
Why the response number 2 is interfering? Why the response number 2 is interfering? Yes, have you have any instructions? Get instructions. No, let them get instructions. Then government seeks time to get instructions. And the petitioner is permitted to take out personal notice to the response number 3 and 4 and file proof of service. List this case on 112. Yes, what do you say? This complaint has been registered in the year 2012, 22. Did not for A. Why? What is the difficulty?
And also the petitioner made a representation to several representation made to the concerned respondent. They have abused of healthy language and they have simply done the issue.
Yes, what do you say? Which police station this one?
These ones are cultural district.
Get instructions. Next week is 1711. AGP seeks time to get instructions. List this case on 1711.
Number 14, Mr. Mahadev.
Please, Lord.
Yes.
Lord. This patient by question inaction of the police, Lord. Page 12, your Lord, we can see FIR was registered on 24/1/2022. Till date, no action has been taken whatsoever.
Yes, learned AGP seeks time to get instructions. List this case on 2411.
Okay.
Number 15, Mr. Venkatia.
Yes. Yes. The writ petition becomes infectious. Yes, this writ petition has been filed, seeking a direction. The respondents to consider the representation of the petitioner.
Rahul Bhatt. Letter number 60.
When the crime was registered. Item number? No, item number 16 here. Yes, what do you say? When the offence has been registered? 17/5/2020. Then why you are conducting investigation into the said offence? Yes, Land Assistant Government Peter 6 time to get restrictions. This case on 1/12/22.
Letter number 70. Durga. This matter that if the respondent not as per the interpreting the civil dispute law, actually the petitioner and the tenant plus the first respondent is the ones of the property law. In between the rental agreement is registered. Then after the petition has been approached the junior civil court obtaining injunction of law. But the court has not written the petition law to withdraw this case and also the rental agreement law.
Instructions are not necessary. What is there in instructions? It is a simple case. Petitioner claims to be a tenant of fourth respondent. And according to the petitioner, there is a rental agreement being entered. When there is a dispute between the owner and the tenant, petitioner, your instructions are not having any weight on the court to pass any orders. I will dispose the petition, right? The petitioner, where is the rental agreement? Where is the rental agreement?
Page number 26.
It is a registered rental deed.
Registered.
It's right.
Document number 1562 of 2000.
Document number 1562 of 2022. 20. Yes.
Offense under section 37A of Telangana Express. And the punishment is up to 7 years. Without following the procedure, my lordship, in which I am arrayed as without following the procedure, my lordship, they are calling me to the police station.
Kandi. The petitioner is the accused in crime number 166 of 2023, dated, registered, dated 2/11/2023.
For police color infiltrated the petitioner. Actually, my problem was the owner of the land matter. Alberta responded to follow 68 respondents. They purchased the property. The owners of the land.
What is the writ petition earlier filed?
These fellows, the authorities never said they are trying to interfere with the people. It's the moderated by the Sample Court.
Page number 35. Yes. Yes, according to you, even after granting interim orders by this court in WP number so and so, at the instance of the private parties, respondent police is interfering with this unit. That is your case. What is the suit 617 of 2023? Then this suit for instituted by you specific performance, you are not the owner of the property. But he is the true owner of the. But he is the true owner of the property. Unless suit is decreed in your favor. But you are entitled to obtain appropriate injunction orders from the pending suit.
This is against the police ballot.
If that is the case, how your petition 4794 is maintainable? So where is the question of revenue?
There are no authority. The petitioner registered old impediments by playing fraud by showing the same property, and he is trying to encroach upon the property which is fenced with the blue shades and covered with it. Then here about 10 criminal cases were registered against the husband for land encroachment. And today the matter is before the court, before the revenue court, where we find a vacate with all the material showing that.
What are you?
And also, like speak to your from this.
Get instructions. Yes, list this case for instructions on 24/11. And we will see. We will see.
Civil dispute is the clear. Criminal cases are there.
We will consider all after instructions.
Number 20.
Yesterday when has been filed. Today is not. This repetition has been filed yesterday. The Jellican guy is suffering fear. What is the matter? For that also, why you required senior counsel's assistance in this matter? What happened to Narendra?
against this armed protest.
Earlier this court? Yes. Now which police is interfering with your position? You want to argue the matter? You want to adjourn the matter only for the? Yes, sir. The request of the learned counsel for the petitioner. List this case on 24/11.
Item number 21, Mr. Kadkaravind.
Yes.
Challenging the action of not about only the ODC, where I used to not to proceed with the election campaign. I'm seeking relief not better not to obstruct my election campaigning or process, but in the similar circumstances to not to pass an order. I'm seeking part of the portion. Is an active member of political party at the base of the local MLA. 10 cases were registered. Out of 10 cases, 5 cases.
List this case on 8/12/2023. Yes, get instructions.
Only say one thing.
No.
Only one thing.
Yes, call the next case.
But I speak only one thing. Number 22. Find over. With regard to find over the water has passed in order.
Yes.
Same victim protection will be used. Let them forward.
Where is that order?
The patient for 45.
This is disposed of.
Yes, sir.
Yes, what do you say?
Patient for 45. That protection is enough for me.
Yes, Randy. The petitioner claims to be. What is your main relief in this writ petition?
With regard to the commission, let them
Then-
counter now due to elections, even the chief electoral officer also written letter to the DGP saying that take appropriate action. Let him participate in the election process.
Where is that letter?
But your lordship will find it. Page number 29.
Yes. Read.
Subject letters complaint petition petition. Copy of the cited forwarded here to the Director General of Police Hyderabad as well as Commissioner for the request to examine the complaint petition as per the rules and implement the action taken directly to the
Okay.
complainant.
Where is the direction in this letter directing the?
He made
This is only examine your representation submitted.
because I narrated the facts. saying
What
that-
is that relief you are asking in this writ petition?
Not to arrest the petitioner, but to find over. The infill relief. Or to interpret the person's life and liberty to right to participate in the upcoming elections.
So far as the facts and circumstances of that case is concerned, it is a little different.
No,
So far as that case, the matter went up to Supreme Court, where is the prevention?
In this case, the entire allegations are made by the local police at the behest of the local MLA. I did set facts before the DGP and Commissioner. Now I'm limited to my prayer, not with regard to the, not against the suspension of any charge.
Where is the representation you have submitted to the?
Lord should be private, not patient, but that
But I am instructed to appear for respond number 6 in this matter.
Yes.
page number 36. No.
Respond number 6 is the station house officer.
No, respond number 6 is the private party, my lord, as per the cause title.
No, you are representing, it seems that in next item, not in this item.
I'm sorry. Apologize.
Yes.
Page number 36. No.
Yes.
The complaint, your lordship will find it. Page number 36.
Yes.
Given to the DGP, specifically alleging that the local MLA.
I will dispose directing the DGP to examine your representation, that's all.
But your lordship may say that the participating
No.
elections.
No. There are two options for you. One is for filing of counter affidavit in your case because a rowdy sheet has been continuously maintaining. Other option is directing the Director General of Police to examine your petition. What is that option?
Second one,
Yes, right.
keeping my petition pending because.
No, no, no.
But now I lose my.
I don't know. I don't know.
The liberty to liberty or what should I grant because the rowdy sheet is.
What is that liberty?
Now I can challenge.
No, you can challenge subsequent writ petition. You can file. This is only disposal of repentation. That's all. Petitioner. Petitioner claims to be an active within a period of within 1 week from today, from the date of receipt of copy of order. Yes.
This order will not.
And it is this order, the disposal of the writ petition will not preclude the petitioner to file appropriate writ petitions, questioning the opening of the rowdy sheet or maintaining the surveillance sheet against the petitioner in accordance with law. Yes. I will issue to CC. We'll get the CC tomorrow.
Right.
Yes.
22. That's law.
Yes. Yes. Yes.
20 acres of land have been purchased for self-explanatory volume storage.
Yes.
Because as indicated in the thing,
Yes.
but so many survey numbers is confined to, but petition prayer is confined to.
Yes.
Survey number 9 and 11 that is out to prayer for instance.
Yes.
This storage is confined.
Yes.
But the history of this case is not this is the land which has been declared as a vacant property.
Yes.
It has been declared as a vacant property.
Yes.
But it has been allotted to the displaced person. I mentioned the name of the area where it has been allotted to. Another has been granted to Ishwari Bari.
So what is that relief you have sought, Mr. Senior Counsel?
What I am asking is sixth.
Who is the sixth respondent?
16.
Who is? No, who is the sixth respondent?
Sixth respondent is claiming the property to the persons who have challenged the notification, evacuate property.
You institute a suit. You are having any right over there?
Allegation already, allegation is in the police, but are supporting it. But in fact, though our rights have been.
See, when there is a specific allegation about the interference of the sixth respondent, what prevented you to
We
institute?
made a complaint. And
See, what prevented you to institute a suit and obtaining an injunction against the sixth respondent?
Point out your options, but what I am saying is, so far as there are two things which I am saying now. Action of protecting our right because our rights have been decided up to the Supreme Court, saying that this is an evacuated property and it has been notified as an evacuated property, which has been challenged by the alleged predecessors of the sixth respondent has been read.
You are appearing for?
But I appear for the sixth respondent. I think the senior counsel has not been properly briefed. The suit OS number 329 of 2018 is pending on the file of Additional Junior Civil Judge Rangareddy District, filed by the petitioners herein against one Raja Gaud and the sixth respondent herein, in respect of the very same property.
Very same relief. Seeking very same.
There is no mention of that in the plaint, in the petition, writ petition. Probably that's why senior counsel might not have been instructed on that.
About the pendency of the suit in the affidavit.
Our friends are concerned, it is not there. My friend says that Sunday, let the matter be posted to 14 because I was not briefed about any suit being there.
Mr. Senior Counsel, I wish to stated in the affidavit about the pendency of the suit against the inter se parties.
It's not there. That is how
It amounts to suppression of the material facts.
Senior counsel might not have been briefed because it is not there in the affidavit.
Sir Prabhakar, Senior Counsels only act upon the instructions being
But
furnished.
that's what I'm saying. He is not properly briefed by the.
Affidavits.
Also may not be aware because the counsel might not, the party might not have informed him.
Basing on the pleadings and the vetting of the affidavits, they will appear.
That's what I'm saying. Senior counsel might not have been briefed, and even the advocate on record may also may not be aware.
See, what is that suit number?
OS number 329 of 2018. Milord, I will pass on a copy of that plaint to my senior counsel by afternoon, Milord. OS number 329 of 2018. On the file of additional junior civil judge, now at Malkajgiri.
Senior Counsel, it is fairly covered by judgment of the Supreme Court in Sri Raghuram versus Bangalore Development Authority.
I said I will not be able to.
That's no, I am not saying to you. The parties has to disclose the whatever materials which are having an impact over the petition.
My friend says that suit is pending the sixth respondent also. It may, but I do not know about the fact.
No, they are stating across the bar. They are saying what is the suit number?
OS number 329 of 2018.
Senior Counsel, it is not attributing anything to you. It is only to
No,
the petition.
I am only saying senior counsel might not have been briefed. I'm saying he has not been briefed. on
Yes,
this.
we will do it. You do one thing, you file a detailed counter affidavit if that
Very
is
well.
the case.
Very
Take
well.
all the, because the Supreme Court recently heavily come down on in the matter of Sri Raghuram versus Bangalore Development Authority, reported in 2022, stating that wherein if the civil cases during the pendency of the civil cases, when the writ petitions have been filed on the file of the High Court under 226 or on the file of the Supreme Court, when the civil suits are having an impact over the decision being taken by in the writ petitions, or the parties in the civil suits are the parties in the writ petition, it is necessarily has to be disclosed the information in the writ affidavit, and writ courts after going through whether the what is the impact of the information being furnished, then only the courts are in a proper way they can dispose. That is an observation being made and dismissed with the cost. If according to you, if they have not disclosed the suit particulars which is having an impact over the case, I will consider the same thing. You file your counter affidavit. I will
Put it to next week, by Wednesday, I'll file my counter. And in fact, I am not attributing anything to Mr. Prakash because we know him.
Nobody can attribute Mr. Prabhakar. I have also assisted a senior counsel for such a long period. You are aware.
That's what we know him, not he is our.
It is only the duty of the petitioner first instance, and second the counsel, and even sometimes parties may not inform about to the counsels also.
Sometimes they don't inform the clients also.
Even uncounted counsels appearing before this court in arguing the writ matter suppresses certain things before the knowledge of the court also. What is wrong in it? Yes, the petitioner is permitted to take out personal notice. If not necessary, notice is not necessary in view of your take.
Today we have filed Wakalat also. Mr. Aziz Hussain takes notice.
Mr. Aziz Hussain takes notice for the sixth respondent and seeks time to file counter affidavit. Yes, Lan Gunpiter seeks time to file counter affidavit. Lan Gunpiter appearing for respondent 1256 seeks time to give instructions. List this case for filing counter affidavit and 8/12/2023. Yes. Reason why I posted 8/12 is there are elections up to 38. All police officers are busy. Therefore, let them file counter affidavit. I will decide on that. Yes.
Our counter is enough. That's enough.
Therefore, I posted on 8/12/2022. After elections are over, results will be over on 5/12. Therefore, I am posting all the cases where the police involvement is there on 8/12. File a counter affidavit. Yes.
Deeply obliged.
Number 20.
Mr. Counsel, you also go through with the judgment of Sri Raghuram versus Bangalore Development Authority, because following the judgment, I have dismissed so many cases with costs. Yes. Yes. No. What is this case? Which item? Which item you are arguing? 20? Yes, you are for petitioner. Yes, what is your case? Yes.
Commissioner, pollution has created a document partition suit against my property.
Created a document of partition suit. Okay, a suit will be created by the municipal commissioner. Municipal commissioner has created a partition deed. What is the role of creating a document by the municipal commissioner, that to a partition deed? How can a municipal commissioner will create a partition deed? Partition deed will be entered by the co-partners, either it is a registered partition deed or it is a recognizing the partition by way of a memorandum of partition. That is the law so far as the partition is concerned. What is the relief you are asking in this? During the pendency of civil suit with regard to interstate parties, with regard to very partition of, you said just now there is a partition suit is pending. So what is that partition deed? Show me the deed. Page? Yes. It is a registered partition deed. How it amounts to collusion? A registered document is a public document. You go before a competent civil court dispute this partition deed and sought for a relief of cancellation of this partition deed, saying that it is not binding on you. I don't know, Mr. Counsel, how can I know that whether property belongs to you or somebody else? And even if I know also, I am not supposed to make any comment in sitting under Article 226. I will do one thing, I will dismiss the writ petition or allow you to withdraw the writ petition. It is your option. No. What is the police? Why should I unnecessarily invite the police into civil disputes? It is conferring power on the police to examine the civil cases. And day by night, and I am dismissing so many cases where the police are interfering with the civil dispute. It is a registered partition deed. Go before a competent civil court, institute a suit for cancellation of the partition deed, saying that they played a fraud on you. In fact, they are the co-partners. You are a co-partner. You are entitled in that partition suit. Deed is not binding on you, and get a declaration decree of cancellation of partition deed, and also share being allotted to you. That is the proper remedy. What police can do? What is the role of the police? When the police is having any power to cancel the registered partition deed? What amounts to cheating? Unless, as long as the partition deed, valid registered partition deed is existing, it is a public document. And the police are not supposed to examine that whether it is a rightly conferred the share or wrongly conferred the share. It is only the competent civil court. Why unnecessarily I have to argue with you in the morning? I will pass in my own orders according to the petition, the grievance of the petitioner. The present petition. Liberty is granting liberty, petition is dismissed as withdrawn.
Number 24. Central Government Policy. Yeah.
2014 matter. What is the notice will now go? What is the case? Tell me. Forget about the notice. Yes. Who is the contractor? What is this proceeding stated 11/7/2014? Yes, read that 11. Yes. Yes. Page 22. The representative of the contractor of Ms. Yashwanta agreed not to dispute while adjudicating adjusting the due wages of the applicant workmen as deposited by the principal employer and the RLC as per the direction against their pending class. The security deposit by the principal employer and the system government is directed to the applicant workman not to raise any dispute with regard to his due wages for the opposite period before any forum of court of law, since the subject matter was amicably settled as per the intervention of the Regional Labour Commissioner, Hyderabad. Yes. Yes. See, Mr. There is a settlement entered on 11th July 2014.
Settlement was done by the done between the second respondent and the first petition hearing, which is the principal contractor. It's the duty of the contractor who has to not pay their work. The project was not working under the last simple employer who is the petition hearing. The second respondent who is the contractor who takes the contract.
Who is appearing for the third respondent? So what are the steps you have taken for that?
Recently, our previously the senior counsel is there. Can you take a commit to take a personal started to the units?
Yes, the request.
Responding to my last section, but we have completed the Bharathan issue then.
No, take notice to all the respondents. The learned counsel for
No such address.
The petition is to. Yes, there is a request of the land council for the petitioner. The land council for the petitioner is permitted to take out personal notice to respond number 3, 2 and 3 and post this writ petition. Not necessary. At the request of the land council for the second respondent repented that he has given up for Kanan. And the no notice was served on the third respondent who is the contesting party in the writ petition. The petitioner is permitted to take out personal notice to respondents 2 and 3. Post this writ petition. And 8 to 15, 12, 2023. Yes. 3 and 4, both the 25 also goes together. Both the parties, the very same parties. So post this writ petition along with these ones. In this case, also take notice. All 4 matters are same. Yes. Yes.
Number 27, Mr. Ravi Kumar,
Yes. So what is the matter? Challenging quash. You are seeking to quash. You are seeking to quash the criminal proceedings. So you are appearing for the respondents. See, this matter is relating to Sachin Computer's case. Yes. What happened to that criminal cases being tried? Cases for trial is still pending before the special court. Trial is now completed long back. Before the special court also, it is pending as on the date. SC number 1 of 2014. The no representation for the petitioner. Why you are bothering when you are, there is no representation for the petitioner? Have we instructed you to represent the matter? No, has he instructed you to represent the matter? And why should you bring to my notice when there was no representation? Therefore, he has to take steps of requesting some counsel. He is in coma. EDS Ravi Kumar means that Nilanji Kemurthy Jr. Some junior lady colleagues are with him earlier. Yes, what do you say? See, it was brought to the notice of this court, the 11th council. Shall I record that statement? They list this case. No representation, list this case on 22/12/2023. Unnecessarily, why should we mention all these things? We're simply posting on 22/12/2023. No, when we are uncertain about this thing, why should we mention? Simply posted on 22, no representation, post this case on 22/12/2023. He will pray the God to soon, let him recover very soon. Yes. Item 28, Mr. Durga. Yes. Yes, who is appearing? So why you filed a dispense with petition? What are the reasons stated? Read the reasons in the affidavit. There is already a petition, dispense with petition, counter affidavit. Yes. Show me the reasons stated in the dispense with petition. Where you have stated in the affidavit.
Page number 3.
Page number 3. Yes. Read. Yes, the application allowed, application IA number 2 of 2023 filed seeking dispense with petition, and they are seeking dispense with is allowed presently. And the presence of the second respondent is dispensed with. List this case for present for appearance of the first respondent on 15/12/2023. Let him appear on the day after elections. What happened to your case? You will see, because of the elections you have stated, and he is the municipal administration officer, court has considered. But he has to appear on the next date of hearing, on 15/12. It is not permanent dispensation. Yes. Yes, the purpose. Before that, try to modify or try to dispose of the case, because I have posted on 15/12. On that day, he has to present. Yes. If anything is, if you have achieved the result in the writ petition or the vacant stay petition, or those cases have been disposed of, you file a memo, I will permanently dispense. Yes.
Item number 49, Mr. Syed Yasir Babu, head teacher.
Yes.
Seeking the matter.
Seeking? Why? So what is your case? First tell me. What is your case? It's a contempt case. What is the directions issued by this court?
Page number 9.
Yes. Read.
Respondent.
Yes.
Respondent of the Deputy Commissioner, Municipal Corporation is also directed to.
Have you filed a status report?
Yes.
Stating what?
Status report.
Hmm.
And several petitioner.
See, I said, meanwhile, the respondent municipal corporation is directed not to allow any illegal constructions by encroaching the public road or blockage of the passage by respondent number 5 and 6 without obtaining construction permission. Is what your report says.
My report says that there is no blockage and there is no encroachment of road. And report filed by USR member.
When you filed?
On the month of 7.
Clearly, sir.
7/7. USR number 61218 of 2023. They also received for the last occasion by certificate. They want to file reply to my report. They filed by commissioner.
Give a copy. You are having other copy. Read the relevant portion. It is filed by the commissioner.
Yes, but filed by commissioner.
Yes, read relevant portion. Paragraph 8.
Number 9.
Para 8 first you read.
Number 8.
కళ్ళతోటి చూస్తే ఎక్స్రే లాగా తీయాలి ఏడు ఉంటుంది అనేది. ఇప్పుడు నువ్వే ఇచ్చినావు కదా, నేను చెప్తూనే ఉన్నా కదా para 8. Yes.
It is submitted that there are no encroachments on road or blockage passage as alleged by the petitioner other than the above mentioned deviations and further action will be initiated against the deviations by the concerned official officer number 6 agency. The photographs are enclosed here with 5%
Yes. Yes, Randy, this petition has been filed. This contempt case has been filed, alleging non-compliance or alleged non-compliance of the orders passed by this court in WP number 845 of 2023.
चलेगा कि
Yes, what is your case?
One of the thing, it is structured by a feet road. Large or take developers like this, they are found as an unauthorized construction. And they have not taken any steps at value. They come in the counter and state that no, it is not study. Two-bedroom scheme and two-bedroom scheme. This respondent is allotted as they are constructing.
Is there any permission is required for the person who has been allotted 100 square yards of land? According to me, below 100 square yards, there is no necessity of any permission being obtained. Earlier it was 80 square yards. Recently it seems to have been enhanced to the 100 square yards. Yes, what do you say about the encroachment of the road portion is concerned? Read relevant portion of your counter affidavit, Mr. Anil. Counter it. Yes. No, let him read. It is his own counter. Yes.
All of the observations of the honor.
I will examine in contempt case. There is no urgency for me. It is my order being violated by the respondent. If you satisfy, they will face the paragraph. Read. Paragraph 5 of your counter. Counter filed by whom? Number 5. Not number 2. Yes, read anyhow. Read counter filed by the number 5. Yes. See, by photograph, it shows that he is constructing villa in an 100 square yards allotted by the government. Is the person below poverty line? He is the Sarpanch of village. He is a below poverty line person. You know that how much of amount is required to spend for election of ward member. I am not saying about the Sarpanch. Are you aware or not? You don't aware. He is constructing villa. He will complete that. What is the difficulty? See, that is with regard to allotment of the government lands. Yes, read the relevant portion. Yes, yes. Where you are reading, Mr. Counsel? I am reading. Reply counter affidavit. You have circulated reply counter, and the counter affidavit filed by the. There is no counter affidavit filed by the respondent. MLA camp office lagundi ledi. Every decision. Maharashtra border. Counter affidavit of first respondent. I am having counter affidavit of
Counter affidavit by first respondent. Counter is by the DPO. Second respondent by the secretary of the.
Yes, second respondent counter is necessary. One minute. Second respondent counter, page 4. Yes, read. See, it is in categorical terms they have stated he is proceeding with the construction in the land allotted by the government to the extent of the assignment patta. And there is no whisper with regard to encroaching the 20 feet road as you stated in your affidavit.
If it is completed, then I take your lordship.
He is completed, his version is over. It is not that much time is required for this court. Yes, now come
Now,
to the.
lordship may kindly come to the counter file by the R1 also. It speaks otherwise. Parent 9, lordship.
Yes, 1 minute. 1 minute.
The teacher says that the
Yes.
allotment is in parent 9.
Yes.
Is in favor of lot is in favor of one Nirida Smita.
Yes.
Parent 9.
Yes. No, that is not the case. The case is,
Just want to bring you.
Mr.
Because in para number 8,
If there is an interstate dispute with regard to allotment of the land, either in favor of Sunita or in favor of the respondent Sarpanch, I am not going into those aspects. Then you have to resolve those disputes. You submit a complaint to the revenue authority saying that in violation of the terms and conditions of assignment pata has been transferred in favor of the Sarpanch. Sarpanch has constructed. This court is confined to the extent of if there is any encroachment on the 20 feet public road. That's all. You satisfy from the counter of the district panchayat officer that he admitted that there is a construction being allowed on 20 feet road.
That to that extent, they are not neither denying nor they are.
You state your claims. You state your claims in the writ petition, pending writ petition.
Because my claim is that they are the only approach road to the plots is that 20 feet.
I don't know.
But actually, because I
I
have.
am only concerned. I am only concerned with regard to the encroachment. You satisfy contrary to the orders of this court.
Lordship may come to 8.
I am not Mr. Sajan. I am not deciding the writ petition. I am only hearing the contempt case. Yes. Yes.
Page 8, your lordship may come to.
Reply.
Yes.
It is more than the affidavit and counter affidavits. Yes.
Page 8 is the sketch of layout. This
Yes.
is assignment, lordship.
Yes.
On the right, left side bottom 161 is the left side next to the road. Your lordship. 161 plot number is B.
161 plot.
On the main road on the main road has been marked here.
Yes.
Next to it 161 plot number.
Yes.
Alright. Now the next plot, next page 9. I've marked how the plot has been. 161 plot has been marked here, and 20 feet road is already existing. And the other open plot is there, which is the mark for the other.
Then what is the proper course for you? If somebody has encroached a road which has been already depicted in the plan or approved layout, we have to institute a suit for removal of the mandatory injunction. And even public road also suit is maintainable. Who said that suit is not maintainable against?
Custodian is the secretary. You need to take care of this road here.
Even if he failure on the part, it is a disputed question whether there is. You have not.
Appoint an independent.
No, I am not here to call some evidence in the writ jurisdiction. You state all these things. See, sir, what is that case I am hearing? What is that case? Therefore, you take steps in the writ petition for appointment of advocate commissioner, and he will verify and he will file a report, appropriate report, and the court will issue if it is necessary for directing them to.
Specifically, they have encroached 20 feet road.
Therefore, in the absence of any material being placed before this court, and this court, while deciding the contempt case, is not in a position to give a finding that there was an encroachment which amounts to allowing your writ petition in a contempt case. Therefore, I will reserve all your right to contest in a writ petition, and you take appropriate steps of contesting the matter. So far as the recording of the statement, if it is a case of the petitioner in contempt case, the district panchayat officer has stated in any of the paragraph that yes, there is an encroachment, they are taking such steps. Yes, you are right. I will examine this.
EPO says that it's a allotment to another.
That is a
Secretary says it's allotment in favor.
that is a disputed question. What way it is concerning with regard to encroachment of the road? If your case is that a person's against a particular person an assignment was granted by the government, particular person is in possession of the property, it amounts to violation of the terms and conditions of assignment. Yes, you are having a case for seeking cancellation of the assignment.
So how the court has been taken to write down.
You have filed only one writ petition of this nature. You have filed one writ petition of this nature. How many cases have you filed contempt of such nature?
Totally. I got on that.
I see. There are so many cases being filed every day. In an assignment being granted in the revenue department, even an assignment being granted, and the contesting parties filed saying that assignment has been granted to the particular person contrary to the conditions of assignment. Therefore, you are having a remedy of relief. File a writ petition immediately, saying that in a counter. Therefore, you are having a separate cause of action questioning the.
It's in violation of the order. That's what I'm stating. More than 100 square yards. It's in violation of the order.
Therefore, you have to file a writ petition challenging taking advantage of the findings being recorded by the district panchayat officer saying that original allotment was in favor of the so and so person, but permission being granted. Therefore, I am closing contempt, leaving it open to state all your grounds.
Is not concealed all the facts.
Sujan, ఏదైనా కంటెంప్ట్ కేసులలో నన్ను ఇరికిస్తే మంచి ఎవిడెన్స్ ఉన్నదంట ఇరికిచ్చి కొట్లాడాలి కోర్టులో. What is this halfway through? It is neither here nor there because the contempt case, you are aware, it is a quasi criminal, quasi civil. Therefore, when this court is proceeding with the contempt in a criminal nature, unless and until there is a strong evidence being placed by you, I am not supposed to exercise my discretion under the provisions of the contempt. It is a criminal case. And always the benefit of doubt goes to him when he filed a counter affidavit saying that there was no illegal construction, there was no encroachment of the road margin. When these issues has to be dealt by in a writ petition by the properly by placing proper evidence. Therefore, you file an appropriate application in that case. I am closing this contempt presently. Yes, and this court. the petitioner has filed a the petitioner seeks permission to withdraw the writ petition. Permission is granted and writ petition is dismissed as withdrawn. I will come back in 10 minutes. Yes. Venom. There was no representation. The council Act 12/10/2023. Case was directed to be listed under the caption for dismissal. Today also there was no representation. This shows that the petitioner is not interested to prosecute the case. Dismiss the petition for non-prosecution.
Item number 33, A4.
There is no representation. The matter was called on 17/8/2020. Case was directed to be listed for dismissal. Today also, there is no representation, even after listing the case. With the caption, dismissal. There is no representation. And therefore, representation for petitioners. Dismiss this case for non-prosecution.
Item number 34, Mr. N. Sridhar.
Yes. The learned counsel appearing for the contempt petition. Counsel appearing for the contempt petitioner established that the orders subject matter of the contempt have been complained. In view of the said submissions, no further orders are necessary. Contempt case is closed. Yes.
Item number 35, Mr. Mohammed Azhar.
Why it was adjourned?
If they are accepting the report and filing an affidavit of acknowledgement.
Yes.
Yes.
What is the difficulty for filing of an affidavit? Tendering unconditional apology, and a court has come to a conclusion. You want a punishment?
No.
Then have you stated?
Yes.
After seeing this counter affidavit only, a suggestion was given, seems to have.
No conclusions they have committed on because they have not accepted the fault. They say if at all there is any shortcoming, they are ready to apologize.
That is a conditional apology. There is no question of it must to come.
You have to contact them to first admit their guilt.
Yes, I will post after vacation. I will hear, and if it is necessary, we will pass appropriate orders. List this red petition contempt case on 15/12/2022.
Item number 36, Mr. Telanganahigh.
Yes, what is the matter? Who is appearing for the respondents? Who is appearing for the petitioner? Yes, any counter affidavit has been filed?
Yes.
Is counter affidavit? Revenue authority also filed counter? Lakshman Babu Tahsildar filed any counter?
Yes.
Counter revenue not responded. Venkat Reddy, revenue divisional officer, Usunagar. Collector filed any counter? Yes, what is your stand, Mr.? You are appearing for? Sir Ravindra Reddy, you are appearing for? Respond number? Respond number 3 is revenue JP. Except Tahsildar, other respondents you are appearing. Who are the other respondents? That is Vinay Krishna Reddy, collector, you are appearing. Yes, what is your stand? Have you filed counter affidavit in contempt case? Collector filed any contempt counter?
Revenue.
You read the counter affidavit of Tahsildar. Who is appearing for third respondent? Tahsildar. Counter reading. Tahsildar. This is the counter filed by the respondent number 3. Who is the respondent number 3? You are appearing for respondent number 3 also. You given up the wakalat. Who is appearing now? Why you have given up wakalat? Matter is pending before. What is that vacate you have filed? What is the directions issued by this court? Who is appearing for the petitioner? That is the additional counter. There is no representation. This contempt case has been filed for alleged violation of the orders passed by this court in IA number 1 of 2021, in WP number 17871 of 2021, dated 11/8/2021. Mr. the constructions. Yes, what do you say in your counter affidavit?
There is some deviation of constant that. Page number 4, paragraph 11.
Paragraph?
Paragraph 11.
Yes.
Deviation of constant that.
Yes. Ready. Page. Counter of. Yes. Read. Page 8. Yes. No, no. Show me from you. What is that you want to state from page 8? Class D setbacks. Front 1.5. Rear side no, not necessary. Side 1 setback not necessary. Side 2 setback not necessary. What more you want? 1.5 so far as the front portion is concerned. They are saying in the counter front portion, I submit that after receiving the said show cause notice, the fourth respondent himself removed, demolished the construction to the extent of deviated portion of front setback on 29/3/2023, except from setback, front setback. No remaining setbacks to be maintained as per the permission accorded to the fourth respondent. Therefore, what is there? He stated, see, if you filed a false affidavit before this court, you file a fresh contempt against him saying that no setbacks, front setbacks have been removed by the fifth respondent. In fact, as stated by the in a counter affidavit, therefore it is a perjury on the part of the first respondent to file such an affidavit. I will initiate action against him. This repetition, this contempt case has been filed for alleged violation of the orders passed by this court dated 17/2/2023 in WP number orders passed by this court in WP number 4600 of 2022 dated 17/2/2023. This court by deposit order directed the respondent 4 and 5 Yes. Item 37. Yes. List along with item 37. 2 weeks. Partition number day 2. 8-12. Yes. Yes.
Number 40. So will come with it.
Yes. What is the matter, Venkatramreddy? What is the order passed by this court? Tell me. Yes. This court is of the considered view that if there are any encroachments made by the fourth respondent, liberty is given to the second respondent Gram Panchayat to initiate action against the fourth respondent strictly in accordance with Panchayat Raj Act for removal of the illegal constructions. Who is appearing for the Panchayat? What do you say? What do you say? Saying what? See, what is that action you initiated? Is there any illegal constructions carried out by the fourth respondent? Then you take steps of vacate of that order. If he has not implemented you, you file an implead application. What happened? What you have stated in this counterfeit. Come to the paragraph E. That is yes.
Paragraph E method, you stated that impedition filed by the second respondent. Paragraph G.
After vacation of the status quo, we will record, we will take appropriate action in pursuance of the notice. See, they have already issued a notice. Questioning the same, we filed a repetition. This court granted a status quo. I will direct them after vacation of the status quo orders.
17 clear on that. If the violation is there, review might take appropriate. Yeah, 30 issued 27 taking action against this data came again hiding the first order.
Therefore, you are entitled to file a appropriate application, including in the said writ petition, stating suppressing the fact of the earlier writ petition wherein this court has granted an interim direction directing the authorities for removal of the alleged encroachments. And that fact was not brought to the notice of the Honorable Court, and he has obtained the orders. Therefore, interim order granted status quo is liable to be vacated, and writ petition is liable to be dismissed on the sole ground of the suppression of the fact, relying upon the judgment of Sri Raghuram versus Building Bangalore Development Authority. Writ petition would be dismissed with the cost of 1 lakh. If that is listed before me, I will impose 2 lakhs. Any other judge, it may be 1 lakh. That is suppression of the ground. Supreme Court said, without even looking into the any other merits, whether he is having 100% case or not, simply dismiss with the cost. Therefore, I will give a liberty to estate all those cases. Ready? This contempt case has been filed for alleged violation of the orders passed by this court in 17th February 2. That is filed by whom? That is a first petition filed by him. See, what is this petition of 23? Yes. It is the
Respondent number 1, the contempt case has filed.
They will take act upon the proceedings issued on 15/4/2023 for removal. Yes. Yes.
Mr. P.V. Raman.
Yes, Mr. Raman.
Please manage the direction granted.
Yes.
It's when I speak.
Yes.
Just 1 2 minutes back.
Yes.
The National Society town is expired. Managing committee town was expired. It's the house building cooperative system. The term of the managing committee expired by March 2020. Very much prior to that, the other body passed a resolution for conducting a no proper channel, all the new percent, along with water, everything, what is required under rule this. Earlier to that period, the society was subjected to biased attitude as a part of one district cooperative office. Number of repetitions for that. As a result, that 51 inquiries, 16 charges, and audit inquiries, multiple inquiries were initiated at distance of one district.
Against these an executive body.
These are executive body. Now we're at March learning has come. Now we're at the same cooperative officers. When it got appointed just before the expiry, a person in charge to take control of the society.
That was suspended.
At that moment, I made a complaint before the classes by finding a reputation. This cooperative, the person in charge will be acting the control of this cooperative district cooperative officer. By that, any elections may not be conducted to the society. Elections passed and interim. This person in charge cannot permit the district cooperative officer to remain interfering in conducting elections on day-to-day administration of government. After taking charge, she asked us to hand over the record of the society. We have stated in the that these earlier original record was at the direction of the same district cooperative officer handed over to the statutory authorities for 51 inquiry and 60 such as officers and audit officer. All original record was handed over. She is also working from the same district cooperative officer's office. You kindly get the original record from the set. In spite of that, her appointment is only for 6 months as acting as a person in charge or at the time of conducting elections, whichever is earlier. Now, even after 9 months, they don't conduct election on the pretext that I have not handed over the record. In spite of telling the fact that all original records were handed over as per the directions to the statutory bodies, which are very much available with the district cooperative officer. In spite of that,
where you have stated with regard to handing over of the records.
Yes.
Please read the relevant portion.
But I find the copies difficult.
No, you read the relevant portion of the said allegation in the affidavit filed in support of the contempt case.
Page 53, 1 second.
Page
53 along with contempt application.
Yes.
Reference 4 is the letter issued by person in charge for handing over records.
Yes.
Daniel versus candidate down to page 54 top.
Yes.
Further, I informed that all the records of the society were handed over long back with the direction of the district cooperative officer, same officer under Fuchila.
Sir.
51 statutory inquiry officer 2016, 51 statutory inquiry officer 2020-21, and 21-22 auditor and 51 inquiry officer and auditor of the cooperative department who attended the audit work and inquiry of the society. Further, we were requested that TCO, Among Vijay Kumari, so many times for original record for day-to-day activities of the society, but she refused. Knowing all the above facts, you are again and again pressing the society to hand over the record. This person in charge.
Who is the person in charge now?
She is the contemporary and I made her as a party. She is also working from the same office instead of getting the records from the colleagues or DCO. Well, this is
Yes, what do you say, madam?
saying this reason they are not conducting elections.
No, obviously, I clearly stated some of the records were given and not complete records they have stated.
What are the records required for the purpose of conducting elections?
Yes, given an inter also.
What are the records required for the purpose of conducting elections? Why the records are required for the purpose of conducting the election? For the purpose of conducting election, you only required whether the members are eligible members to participate in the election or not, and the preparation of the draft electoral notification. And no, I am only asking you, not with regard to stating something in the affidavit. What are the records required for the purpose of conducting election? I know, Mr. Ramana, under the rules, before preparation of the voters list, under the cooperative rules, you are entitled to circulate the draft voters list. And after finalization of the draft voter list, you are entitled to finalize the final voters list. In pursuance of final voters list, you are supposed to conduct the election. Even if there is any illegalities being committed by the earlier executive managing committee of the society, you are in a worst situation, you are entitled to initiate the proceedings under section 51, or under, if any finality is there with regard to fixation of the misappropriation of amount, you are entitled to initiate proceedings under section 60 of the Act. Or under section 37, you are entitled to appoint a person in charge. I am also GP for the cooperative societies. No, don't tell me all these irregularities. Your duty is only to conduct the elections. Instead of conducting the elections, you want to enjoy the position of the public representatives. As an officer, you are now enjoying both the positions. Therefore, I will direct whatever salary you have drawn. Madam, I will direct the government whatever salary you have drawn as an in charge or a assistant registrar of cooperative person in charge of the cooperative society, that shall not be paid to you because you are enjoying the position as a person in charge. You enjoy whatever emoluments you have received as a person in charge. Don't draw the salaries.
We have already addressed a letter to the.
Don't tell all these things, madam.
Once your lordship may kindly see the letter, your lordship.
What is that letter?
Already on 11/7, she has addressed a letter that.
Saying what? What are the records required for the purpose of conducting election? Yes, show me that letter which you have stated. Additional counter. Yes. Yes, page number 9. Yes. Why these records are required for the purpose of bank passbook, checkbook, cash book, minutes book? Wait, Mr. Ramana.
Next page.
Yes.
Further, you have informed me that you have handed over the.
Yes. Further, you have informed that you have handed over the admission registers of volume 1 to 4 to the district cooperative officer, long back, and informed me that you have submitted the following documents to the DCO of the PSC, even though you have never submitted those material to me directly. What does it mean? That is, those records are in your office only. Voters list, membership list, election proposals, bylaw copies, previous election proceedings, GB resolutions. Has she addressed any of the letter to the district cooperative officer to furnish those records to her?
Page 5 along with additional the documents, their acknowledgement also.
Mr. Ramana, you wait. See, since she hails from the same office, have she addressed any letter to the district cooperative officer saying that she has received a letter from the society saying that these documents have been handed over to the district cooperative officer? Therefore, please in turn hand over these records to enable me to proceed for conducting of elections. Have you ever addressed any letter? What need to verify? Yes, issue form 1.
Already we have.
Which respondent?
Respondent.
Issue form 1 to the respondent. Is this case after 4 weeks? That is only the case. You have to simply say that, Ramana, why you are arguing all these things? Yes. Whatever may be, interim order is also an order, and you are aware or not, there is a judgment of the Supreme Court, 99 Supreme Court. Even after dismissal of the writ petition also contempt lies.
Even after vacation of interim order.
Even after vacation of the interim order, even after dismissal of the writ petition also interim order lies. Only contempt won't lie when there is a vacant stay petition is pending and appeal is pending. That's all. Those are the only 2 grounds. This court aware, madam. You are also AGP with me when I was a GP. Yes. Yes. Therefore, you are aware very much about the functioning of your GP at the relevant point of time. Yes. Why, madam?
Respondent has filed in counters for us. This has to
argue now. What is the difficulty? But how many times you want adjournment of this matter? He is out of station from 22/9. Don't say the reason of counsel appearing in Andhra High Court. Ours is also Andhra High Court constituted under the provisions of the Constitution. Say that personal inconvenience, but don't say the reason of he is appearing in Andhra High Court. That is a ground for dismissal of your case. And this court is very rigid so far as such submissions being made by any counsel. Because ours also equivalently, and compared to the Andhra High Court, our High Court is the more older than the Andhra High Court. Reason is it is Hyderabad High Court. And Hyderabad High Court is not the High Court. Hyderabad High Court is the Supreme Court for the princely state of the Hyderabad. And Supreme Court is High Court by virtue of merger of Hyderabad state into Indian Union. The status of the Supreme Court has been given to the status of High Court. Because it is a princely status, so High Court and Supreme Court. Yes. When do you want? No urgency. Yes. List this case on 1 to 8. Yes, Ramakrishna. Yes, who is appearing for the petitioner? Yes, what do you say? See, what is the order granted by this court? Yes, read relevant portion, Mr. Praveen Kumar.
After the rest of this content, the order stating that the compliance of the order dated 4/6/2019, asked by the TSHC has initiated the action for removal of the unauthorized construction, and same was informed to the petitioner by procedure. And that's the representation. The municipal corporation directed to examine the same strictly in accordance with law and remove the illegal construction if any made out of the subject property. The opposite direction it is put down.
It is his contention you are not removing the all illegal constructions. But you read the last paragraph of the very same writ petition order. In view of the directions given in this in the writ petition, the cause in the contempt case does not survive for further adjudgment. Contempt case is called. But however, it is always open to the petitioner as and when he found the illegal constructions. What is the allegation in the contempt case now?
Contempt case allegation is that already we have removed the entire illegal construction by taking measurement.
If they are proceeding with the fresh illegal constructions, then you issue a notice and remove the same.
Yes.
According to you, what is your allegation in the contempt case? Where is the photographs you have filed in contempt case? Reply affidavit. Yes. Yes, show me the page. Yes, which page you want to rely upon the counter affidavit? These are the photographs. These are the constructions according to you.
Yes, sir.
What is this construction? It is only a temporary shed. Which sheds? What compound? Where is that compound wall photographs? When the compound wall was constructed? After institution of the writ petition or prior to institution of the writ petition? Go before civil court, institute a suit for the mandatory injunction for removal of the construction of compound wall. If you are having any claim over the compound wall being constructed illegally or encroaching your property. And by pending adjudication of the civil suit, how your petition is maintainable? Because you specifically stated in the writ affidavit in last paragraph that you have not instituted any suit or other proceedings seeking very similar relief. Have you stated in your affidavit about the pendency of the civil suit? Sir, whether demolition is having an impact over the decision being taken in the writ petition, that is very crucial issue to be bring to the notice of the honorable court. Have you stated in your affidavit about this fact?
Only interim injection I have explained in civil court.
What interim injunction?
Restraining the respondent.
What restrainment you are asking?
Restraining
There is already a constructed compound wall is there.
restraining from property.
When a person who is found to be in possession of the property, how can court will issue a restraining order? Court will only restrain the person for encroaching or trespassing into the land. But person who is enjoying the land, you are only having the right to institute the suit for eviction or consequential possession. Till the disposal of the suit, he has completed his construction work. Amend the prayer in the injunction suit as a mandatory injunction for removal of the illegal constructions. You are having such a power to amend the suit.
He's pending, sir.
What is that you want to do in the contempt case? Tell me.
Totally demolition. There are two portions of.
So where is your counter?
Because after that, filing report to apply of the demolition. Counter already long back filed. He filed.
Where is that report?
Yes. He filed a reply on the second.
No, you have not filed the report as a part of the record. అదే మొత్తం తీసేసారు కదా ఏం కనబడతలేదు ఇక్కడ కాదా మొత్తం సీయింగ్ ది ఫోటోగ్రాఫ్స్ డిస్క్లోజెస్ దట్ దే హావ్ రిమూవ్డ్ ఎవ్రీథింగ్ అలా కట్టుకునేమో వాడు నేను అద్దాలు పెట్టుకొని చూస్తున్నా బహుశా నీకు ఆ ప్రాబ్లం ఇట్లా ఏమన్నా ఉందేమో నాకు క్లియర్ కనబడుతుంది రిమూవ్ చేసినట్టు నీకెందుకు కనబడతలేదు అంటున్నాను నువ్వు చూడలేదా ఫోటోగ్రాఫ్స్ ట్రై చేసిన రిపోర్ట్ తో హ్యావ్ యూ నాట్ సర్వ్ ది కాపీ ఆఫ్ ది రిపోర్ట్ సీ ది ఫోటోగ్రాఫ్స్ దే ఫైల్ ఇది హమాస్ మీద ఇజ్రాయెల్ దాడి చేసినట్టుంది గాజా సిటీ మీద ఐఎమ్ సేయింగ్ ఇన్ క్లియర్ టర్మ్స్ బాంబింగ్ చేసినట్టు ఉన్నది వాళ్ళు డిమాలిషన్ చేసినట్టు కూడా కాదు చిన్న చిన్న ఇటుకలు బిటికలు అన్ని వాళ్ళ కొట్టిరు ఇది దేని పనికి వస్తుందా ఇంకా బర్రెలు కూడా కట్టే రాదు ఇలా See, I have given a liberty to you on last occasion by disposing the writ petition. If further, if any construction is being carried out by the respondent illegally, you are entitled to submit a representation and municipality will act according to law. వాళ్ళు డిమాలిష్ చేసి వెళ్ళిపోయారు వాడు మళ్ళా కట్టుకునేమో మళ్ళీ రిప్రజెంటేషన్ మళ్ళీ కూడా కొడతారు నువ్వు నీ పని చేస్తుంటావు వాళ్ళు పని చేస్తుంటారు నా పని నేను చేస్తుంటా పంచాయతీ ఏడుంది మళ్ళీ చేస్తా అనుకుంటేనే మళ్ళీ పంచాయతీ పెడతారు See, while disposing the writ petition, a specific direction was given. In the event of future also, after removal of the illegal constructions, it has brought to the notice of the municipal corporation that any illegal constructions. ఇది హైదరాబాద్ లో అలవాటు వాళ్ళు కులగొట్టిపోతారు మళ్ళీ కడతారు వాళ్ళు కులగొట్టిపోతారు మళ్ళీ కడతారు తట్ట గుంజుకోపోతారు పార గుంజుకోపోతారు ఇసుక గుంజుకోపోతారు మళ్ళీ తీసుకొస్తారు కడతారు నువ్వు హైదరాబాద్ సిటిజన్ కావా మరి నీకు ఇవన్నీ తెలిసి ఉండాలి నీకు ఏం కావాలి అది చెప్పరా అదిగో ఈ దూడి ఫోటో మొత్తం కింద పడ్డది షెడ్ అంతా ఏం లేకుండా ఏం కావాలి నీకు క్లీన్ చేసి ఆ ఫ్లాట్ వాళ్ళు తీసుకొచ్చి నీకు హ్యాండ్ ఓవర్ చేయాలి అంతే నీకు ప్రాబ్లం డిమాలిష్ చేసింది కదా ఇదేంది ఏ ఫైల్ రిపోర్ట్
already filed on 22nd September. And this reply colored and photographs and report on 29th September.
26/9. Yes.
After filing, he was very much present at the scene.
See, you do one thing, you file a complaint. The file of the very same municipality saying that acting upon the court order dated so and so, the municipality has demolished the structures. But even after the demolition of the structure, the respondent has further proceeded to construct illegal construction. Therefore, same may be removed and వాళ్ళకు representation ఇయ్యి. అవి యాక్షన్ తీసుకుంటారా మళ్ళీ ఒక రిట్ పిటిషన్ అయ్యి మళ్ళీ ఒక డైరెక్షన్ వస్తుంది నీకు మళ్ళీ డిమాలిష్ చేస్తారు డేట్ ఎందుకు మళ్ళీ ఇంతసేపు అయినాక కోర్టును మిస్లీడ్ చేస్తున్నట్టు Are you ready to bear the expenditure of the advocate commissioner? 25,000 కట్టుకుంటావా? What do you say?
He was very much present at the scene by demolishing.
See, are you ready to pay the cost of the advocate commissioner?
Yes, ma'am.
Yes, ma'am. This court by order stated. Disposed of the writ petition. On 120, disposed of the writ petition. List this case on 24/11/2020. 24/11. Yes, madam.
The ten tax was executed, the petitioner was executed in the year 13.
Yes, what do you say? Second. Case of the petitioners is accused in crime number 471 of 2007.
road number 46.
Yes.
Was taking the action of the sixth floor. But not any action.
So what is the interim direction granted by this court? Yes. What is your? So you don't want to take any action? See, fifth floor also according to what is the sanction plan? Huh? But why you allowed fifth and sixth? When you have issued a notice? When you have issued a notice? Is 25? What is the reply submitted by the petitioner therein? The accused respondent. See, according to petitioner has raised, respondent has raised two constructions, additional floors. One is fourth and fifth floor. The fifth and sixth floor. You have only removed sixth floor. What happened to the fifth floor? While removing the sixth floor, what prevented you to remove the fifth floor also? You issue a notice for eviction of the purchasers that does not have ground for the continuing in illegal possession. Throw them out. Throw them out. Otherwise, he can plant some persons into that floor saying that he has given it to the rent and he entered a rental agreement. Therefore, the tenants are continuing in the premises. Does it mean that your powers have been taken away by such an action? He will say that tomorrow that he has entered a rental agreement, a registered rental agreement. Therefore, tenants are there not to demolish. When you have issued a notice, so what is that action you have taken as on today? Issue Form 1. To the respondent. Let him appear and report what is that action he has taken. This is a fit case of imposing the punishment. Yes, issue Form 1 and list this case after 4 weeks. Latest. The list. Inform your commission it is a fit case. I am seeing since so many days. Yes. Yes. Why? It is a contempt case. Your presence is not required. It is an order alleged to have been violated the court order. I will take care of my own order whether there is a violation or not. Yes. What is the direction issued by the school? Yes, Mr. Madhav. That is not the answer. Counter file is not the answer. You have to argue the case. Status quo obtaining as and today shall be maintained. This is the order granted by this court. What is your allegation? They have demolished the shed and what date they have demolished? Yes, when this court granted an order. Yes, why you have demolished? What is the answer in the counter? Yes, what is that evidence you are having to say? What is that proof you have enclosed in support of your contention in the counter affidavit file in contempt case that the orders issued by this court has been served on the respondent? See, when the orders have been granted by this court? 17th day of April. See, when you have served the order copy on the other side. He says in para 13 that it is submitted that subsequent extension of the order copy dated 17/4/2023 of this honorable court has not been received by this answering respondent and thereby there has no knowledge of extension of interim orders dated 17/4/2025. Have you filed at least any representation saying that the earlier order granted, which is valid up to 17/4/2023, was extended?
They have given copy. Same copy we have shown in the,
See, 17/4/2023, initial order was in operation. Subsequently, it was extended according to you. Have you submitted an extension of the order copy to the respondent? Or else at least you have submitted a representation saying that the orders dated 17/4/2023 was extended for further period, therefore not to proceed with the demolition. Here you have stated in your affidavit. Para 4. Yes, read. There is the acknowledgement submission of the order copy. Have you enclosed in support of the contempt petition? Submitting the extension order copy to the respondents, have you enclosed the copy of the same? For not following, I followed the case. See, initial order dated 11/4/2023 was in operation up to 17/4. According to you, 17/4 was extended up to 17/10/7. And you have immediately submitted the copies on the respondent. The contention of the respondent is he has not received any extension order copy. Where you have still filed, have you filed any acknowledgement to say that the extension order copy has been submitted to the respondent? Or at least you have filed a representation saying that earlier orders have been extended by the High Court. Please receive. Where is that? Why you have not filed along with this writ petition, that copy of the contempt petition? Where is that acknowledgement I am asking? It is a criminal case, proof is required. Here is that acknowledgement. Why you have not filed along with the contempt case? Yes, there is a request of the learned counsel for the petitioner. List this case. When do you want? List this case on 17/11. Yes, what is this matter, Mr. Nadesh?
Page number unauthorized construction.
Yes.
Concerned was they are not taking any action. Subsequently, they filed a writ petition. Interim order has been passed by the lordship by the counter. Now I find a vacate in the writ petition. Vacate has been reserved for order.
Before fourth court.
What is
List this case.
even that also they can take action here?
We will consider. They have not taken action. We are not here to beg the respondents to take an action. We will take.
They have constructed, they have reserved.
We will. You wait. It is reserved for orders. Yes, list this case on 8/12/2023.
Number 48.
Yes, what is the matter, Mr. Praveen?
Page number 16.
Yes.
Stop the illegal construction.
Yes.
Then we will stop the workmen and counter and stop down there.
Yes. What is his allegation?
Allegation now is that he only for taking action on the illegal construction.
Where you have stated in the counter, read the relevant. Yes.
There are number 6.
Yes.
The corporation subject of under the court by respondent group was approved and stop the illegal construction made by the unofficial respondent. After that, detailed speaking order by so dated 17/8/2023. Pass directly unofficial respondent to remove the said illegal unauthorized structures within a period of 50 days from the date of the receipt of the copy of the order. Failing which the same will be demolished by foreign by the corporation. Thus, that speaking order and show cause notice out and the parties by pasting on the wall to the main entrance. The purpose of it does the respondent refuse to receive the show cause notice and speaking order and also paste on the main entrance. And the mob and mockery from the neighboring houses to prevent the corporation staff for implementing of the orders. For which the appropriate steps is being taken by the corporation to implement the orders passed on the.
Yes, this is the counter affidavit filed by you on 28th August 2023. What is the steps you have taken after filing of the counter affidavit? That mockery, according to you, interfere with the removal of the illegal constructions by the municipal corporation, obstructed you.
Yes.
And what is that steps you have taken after filing of the counter affidavit? Have you filed any requisition to the police department to provide the police protection for implementation of the court order for removal of the illegal or unauthorized constructions?
This was brought to the notice of the Honorable Court and then subsequently Deputy Commissioner Maharaj, he requested the police officials to outcome.
Where is that?
And the remaining authorities, because there is a difficulty Maharaj in that November, March, August and September.
What is the difficulty?
These officials, Maharaj,
Say that the state government is not in a position to implement the court orders and the requisite police personnel being not defeated, we will request the President of India to impose the president rule, because when the state government is failure on administration to implement the court orders, it shows that you are not in a position to discharge the functions, administrative functions. It is a ground for recommendation for the dissolving your government also.
that is, they made a request for in writing. Maharaj,
Say by filing a counter affidavit, you are not in a position to implement the court orders.
file that material papers for stating that we already in writing we requested the police officer to provide.
Police official will say that they never received any request from the municipal commissioner.
That I said it because I already instructed.
Inform your officers by the next date of hearing if the illegal constructions have not been removed, saying that mockery has come, politicians have come with some flags, agendas, dharna chesiru, ivan cheppodda ani cheppu, ivan chesi idiki vachi kustunnam guys. Don't tell me all these things. If it is not, order has not been implemented, matter will be viewed very seriously. No. Stopped means stopping. You have to remove the illegal constructions also. Yes, this case. The Land Council for the Municipal Corporation is directed to find the progress of the constructions, the progress report for removal of the illegal unauthorized constructions over the subject property by the next date of hearing. Yes, this case on 8/12/2023. 15/12 KND, 8/12 and immediate elections.
Developer partnering, actually,
What is the case? What is the orders granted by this court? How it amounts to contempt? See, this court directed you not to interfere with the civil disputes except conducting investigation in crime number 594 of 2020. What is your answer and show?
We filed a charge sheet by the CC 634/2021.
Yes.
Put it additional Metropolitan Magistrate Melon.
Yes.
Not interfering in this matter. Investigation Melon, we filed our charge sheet by.
Yes, what do you say?
Also, the respondents have to file on. This is civil dispute Melon. Based on the complaint of the lead superintendent Melon, the respondent number.
Nothing else is there in this case. First respondent has already filed a counter affidavit. Is ready.
My submission.
It is for the court to take cognizance of the contempt. It is a court order. It is not your case. It is case of the court. Yes, right. This repetition. This contempt case has been filed alleging violation of for alleged violation of orders passed by this court in WP number 125 of Yes. Yes. Yes.
The order, to find the order is
Page?
15.
Yes.
Can it would be 16?
Yes.
Bottom page.
Yes.
Before directed to company the order dated 28 February 2020 passed by people. This 41 is and report.
Yes.
Rather than order part giving bench a comprehensive order.
Yes.
Giving a direction, a general direction. The municipal commissioner dealing with all the legal steps.
Yes.
Take that order at page 52.
Yes.
Page
52.
52.
Yes.
The 2 pages number 52.
Yes.
Second page.
Yes.
Let's read the entire order. The usual order. A large number of cases, infections and infections, particular definitions have been filed this program. Is deemed with illegal construction being based all over the city. Illegal constructions are almost in urban units, which are being destroyed, which are leading to destroy not just natural resources in the city, but even the lives of citizens. Slowly but surely, the beautiful city of Hyderabad is turning into an urban nightmare. It is high time that the illegal construction are dealt with public registry. Therefore, the registry is directed to tax inspection in all the requisitions, including the requisition public applications. Kindly go to the last part. Meanwhile, the Commissioner TSHC is directed to examine every single complaint with regard to illegal construction and to inform this court as to the wrong steps taken by DHMC with regard to the said illegal construction. In case this court comes to a conclusion that DHMC has failed to discharge its duty in implementing the law and is stopping the minutes of illegal construction being raised in the city, an extremely serious action shall be taken by this court. A copy of this order shall be communicated to the Commissioner DHMC and the Principal Secretary of Municipal Administration. Immediately for the information, Commissioner DHMC and Municipal Secretary directed to the concerned.
Yes.
This is what is expected by the different bench.
Yes.
And you have clearly directed that the different bench order should be ordered and the report should be filed in this request.
Yes.
Till date, they have not filed any report.
Yes. What do you say?
It's not really that much. There is something more. There's a telltale story.
First, we will take question to the what is the steps they have taken in filing of the report. Yes.
In this present case, Your Lordship,
Have you filed a report or not?
Lordship, we have filed a counter in this present contempt, Your Lordship. Lordship, in this present case, Your Lordship, pursuant to the order, Your Lordship, as all the statutory notices have been served, Your Lordship, we have demolished the structure and it has been accepted by the petitioner in their affidavit itself. Your Lordship, pursuant to that, Your Lordship, what has happened is, Your Lordship, we got to know that the respondent in this petition has reconstructed it. So we have again inspected the property, Your Lordship. After inspecting the property, they have given us a building permission dated 16/5/2023 received by them from the head office. We have inspected the building in accordance with the building permission and measured the property and found that it is in accordance with the building permission. In
accordance with the sanction permission.
In accordance with the sanction plan issued by the head office, Your Lordship. But the only discrepancy is, Your Lordship, the permission is for residential use, but they are using it for a commercial purpose. We have issued a speaking order, final order on 18/8/23, Your Lordship. 18/8/23. It is there in our counter, Your Lordship, asking them to bring the building in conformity with the residential usage. Pursuant to that, Your Lordship, they have approached this, the unsealed respondents have approached this honorable court, Your Lordship.
They filed a writ petition. This court granted a stay.
This court disposed of the matter,
saying what?
Stage, asking us to follow due procedure all over again and setting aside the 18/8 order.
Yes. What happened?
Lordship, this order was on 17/10, Your Lordship. Lordship, due to the elections, Your Lordship, they couldn't do the needful use.
Yes. What is your answer?
There is something more to be said. What I'll demonstrate that how these officers are circumventing the court's order in collusion with the constitution.
That we will hear after the elections. Since all the officers are now busy with the elections. Officers are busy with no. Even if there, yes, that is the reason why I'm saying, since all the officers are busy with the elections, after hearing the case, after vacations, we will take a decision whether Form 1 has to be issued or what are the next steps has to be taken, whether any commissioner has to be appointed or the constructions which have been alleged to have been carried out.
I'm not insisting that you are as an audit today. I'll just take an important fact. How they circumvented the order, how they played fraud on this, how these officers circumvented. There was an illegal construction. And that construction was being used in a dead-end road in Jubilees by a very influential person. All the neighbors in the dead-end road, in that lane, complained to the municipality. Notices were issued. After that, when we complained, notices were issued. Then they are the just a 6 months they remain silent. Then we find a requisition, one more notice is issued. Then thereafter, the unofficial respondent in the requisition comes, files a requisition, questioning the very same notice. This court says, you treat that notice as a final notice and give an explanation. He doesn't give an explanation. Then they go to demolish the building. They don't demolish the building. They just holes here and there. Get that. That's what we have specifically said. The building remains intact. Then this requisition is filed. You also change this direction. After this, what they do is, what is curious is, a building which is constructed illegally without any sanction plan, now without reference to any statutory provision, there is no provision to my knowledge in the Municipal Corporation Act that the building which is constructed illegally without a permission, for that building, existing building, the sanction plan is granted now. Only to circumvent this sanction.
How can you grant a sanction subsequent to the building being erected? Under which provision enables you? You are only having power under 455 AAA for regulation of the constructions, subject to the certain power being sanctioned by the legislative sanction. Because earlier GO has been issued for fixing certain period under 455A. Which provision enables you to grant a sanction permission?
For a building which is already constructed without a permission.
The instructions on that, my instructions are, we find the counter, they obtain the building permission.
How can they obtain a building permission? You question that building permission.
That we are doing.
You are entitled to question that building permission.
That we are certainly challenging. The question is, can they recommend the order? This one will court instead of filing a report. Just they can regulate, they can give a sanction plan and show, camouflage that and say that I with the building.
Yes, why you have not filed a report even after the directions of this court? No, I am not asking.
But the next day of hearing, they file a report also with all the subsequent facts, the events after here, with all the repetition.
What is that action you have taken from the orders passed by this court on 17/10/2023? So almost all we are in the month of November. This court only set aside the earlier orders issued by you and remanded the matter for considering the objections submitted by the petitioner therein and passing appropriate order. What are the steps you have taken from 17/10/2023?
We have to take an action. We are issuing a fresh notice.
Don't tell me all these notices issued, all these things. Notice will be issued fixing a time of 15 days. If no explanation has been submitted, you issue a final notice under section 636 and demolish the structure. That is only the power being vested with you. You want to facilitate the person who has proceeded with illegal construction.
We'll follow due process law and issue the notices and.
What do you mean due process of law? Due process of law means to facilitate the person who proceeded with illegal constructions to get an order from the either civil court from the high court. That is the due process of law. Yes.
This order has been set aside. We have to follow the due process of law or to all that altogether.
May I just clarify one more aspect? After this illegal construction, the sanction plan is granted to this illegal construction. Just as I watched in the counter, they come up with a defense saying that now since that person is utilizing the building for a different purpose other than what is intended, they issue a notice. That is the 88 notice. That notice is under challenge. They are not concerned about the use of the building. They are concerned about the very existence of the building. And that notice that is affecting it to some other use is challenged in a subsequent reflection where this court said now in the latest reflection that you issue short of notice. That's all. That does not mean the building which is existing there will become legally valid.
Issue Form 1.
Give us the date you have to find the gateway instructions.
Issue Form 1 for the respondents 2 and 3. Presently. Officer, let him come.
Who is the commissioner?
Yes, who is the deputy commissioner? Who issued the sanction post ratification?
Issued by the head office in the commissioner's office.
Therefore, whether she is aware.
When they remain silent, they act as silent spectators. Now they take shelter under the order passed by the commissioner.
Yes. 4 weeks, 8 to 12 years. Yes. 4 weeks. Yes.
Yeah, 8.
Yes. 8 to 12.
Item number 51.
Meanwhile, let you satisfy this court that you are having a power under the provisions of Municipal Corporation Act for granting a post-ratification sanction order. If you fail, you are also entitled to file a writ petition questioning the same. File a writ petition, seek a suspension of that order. No, why I am suggesting you is if that order has been suspended, ultimately there is no defense for the respondents insofar as this case is concerned. Yes.
Item number 51.
Nothing remains in this contempt case accordingly. The land council appearing for the petitioner has submitted in complaints of the orders of this court. The respondents have removed the illegal unauthorized constructions and the cause in the contempt case does not survive for further adjudication. Recording the said submissions, this contempt case is closed as no further orders are necessary. Next item. Both are the same. What do you say, Shankar? Settle చేసింటో బయట. Yes. Both the cases, same order. Separate orders, right? Both the cases. Yes.
Number 53.
Is any counter affidavit has been filed? What is their stand?
This is necessary because he may escape from the criminal liability. He may escape from the criminal liability, but he was arrested.
See, as for the Arnesh Kumar case, as for the guidelines guideline number 6 and 7 issued by the Supreme Court. See, if the police officer or investigation officer is prima facie of the opinion that your arrest is necessary, by recording reasons, he is entitled to do so.
He can record the reason he can arrest. But it cannot be a routine mechanism.
That is your allegation in the contempt case. It is a routine manner. What they have stated. Read paragraph 6 of the counter affidavit. నేను చెప్పిన తర్వాత నువ్వు వేస్తాంటావా ఎప్పుడు నేను రాత్రి చదువుకొని వస్తాను పొద్దుగా చదువుతావు reading is very good. Yes. Yes, read.
Respectfully submitted that accused given right for India for Dubai to drag the investigation. Such reports by full position against the action of the minister as the Lucknow Airport authorities executed the court circular on 1st August 2023 and handed over the passport of accused member to assess the accused Western Gardens. According to the counter, he wanted to go to Dubai. In fact, he came from Dubai to India. He went to Dubai in 2nd June. This present crime was registered on 7th June 2023. But
see, this lookout circular was issued on 1/8/2023 after subsequent to the registration of the crime. Yes.
The Russian guy, he said he tried to go to Dubai. But demand is there. He said that he may go to Dubai. Because he was arrested by
nothing else is there in this case. In appropriate case, you try. It is not a case. Nothing, Mr. Ravi.
Arnesh Kumar specifically said they have to report the result and they have to be
Yes, right. This contempt case has been filed, alleging violation of law responsibilities. directly arrested, yes, you are right in saying. You have been secured in the airport, Lucknow airport.
What he said, he is trying to go.
But that there is no much difference. It is not intentional saying. Unless there is an intention, deliberate, dishonest intention on the part of the contemptor, this court is not supposed to exercise its discretion powers of the Contempt of Courts Act. Even for a moment, assume that there is a content. Still, if it is not satisfied the requirement of deliberate intention, willful intention, to lower the dignity of this court, interfering into administration of the justice, these are the grounds for the defense grounds available to the respondents. In all four grounds, your case is fit to exonerate him from the contempt. X. अच्छा केस जो है वो लड़ो, फिर कोशिश करो उसमें। कुछ भी नहीं है इसमें, कुछ भी नहीं है इसमें। उसको सताने के लिए तुम कंटेम्प्ट फाइले और उन्हें गए गवर्नमेंट फेडरल ऑफिस को 5,000 10,000 जीपी को दे दिए, हो गए, बस तुम्हारा जो भी रिलीफ आ गए आगे। Yes, we can. First you argue 50. Yes. Yes. Case 13. Yes.
Is interfering with civil disputes and police working ability to respond. We have the above there shall be active directions to respond. Not interfering in dispute between the petitioner and the respondent of any manner in accordance with law.
Yes.
Not directed to proceed any without any in accordance with law. They are supposed to without anything. They often without they report into the petitioner's land without I find the photograph without to substantiate my contention that without 57 number of police without entered into the petitioner's premises without the break the gates without they disposes without the petitioners by entering. No notice has been issued. And I also
any counter affidavit has been filed. You are appearing for? Who is the respondent number 1, 2, 3? Yes, what is your stand?
But the petitioner will not allegedly purchase the property in the month of January 2020. This is a similar trespass case was registered in the year 2020. And the pleaded guilty and they admitted saying that they have entered into the premises and they have paid the fine and they have been convicted. I find that judgment copy also.
Who has been convicted?
The petitioner's predecessor. They have alleged, they say that they have.
That means either a vendor or a predecessor in interest of the petitioner has been convicted for the criminal trespass.
Yes, sir. Criminal trespass, they have.
Yes.
I find the judgment copy.
Yes.
I purchased this petitioner's the owners in the investigation, it has come to light that they were purchased in the year 2007. It is only basing on the complaint that the FIR was registered. This order, your lordship.
So, what do you say about the photographs?
The photographs that were submitted on 14/7/2023, my lordships have granted the order. After that, 2 FIRs were registered. I find the copy of.
According to these photographs have been taken prior to the registration of the crime.
Subsequently, subsequently in the month of August, after your lordship's order, a FIR was registered. That FIR, they are questioning. All 3 FIRs are under investigation. The entire mob came into the premises. Subsequently, the complaint was lodged by the owners because she is a old lady. Her son filed a complaint. Based on that, there was a law and order issue there. We went there and we have only went into the premises there. We came back. This petitioner started taking photographs, videos, and some of the photos and videographs obtaining to July. Kindly see these photographs also. We have not involved in the civil disputes pertaining to the.
Yes, what do you say?
We have not deviated the order of this honorable.
I will leave it to you to state all your claims in the writ petition because it is your own intent direction.
when they did not even issue any notice, they still have it, in spite of the direction of this honorable court, they came to.
See, is it true or not? Tell me, your vendor, Mr. E. No dispute. Is it true or not? Tell me that your vendor, that your predecessor in interest be convicted in a case earlier when he has entered into trespass into the petitioner's property or not. You have succeeded the property from your vendor or predecessors in interest. Have you entered into the position? Where is the question of you are entering into the position when your vendor, against your vendor, when the criminal court has given a finding?
61, page 61.
Page 61. Nothing else is there. You are trying to take forceful position, therefore rightly the police are rendered clear. And don't.
Whether they without following this procedure.
Where is the question of they are following the procedure when you are not in a position? This repetition, this court has the repetition, you state all your claims in the repetition. This court by interim order stated. This court by interim orders, this court granted interim orders in WP number 18468. This court granted interim orders in repetition dated 14 Yes. Yes. Yes, Madhavrao. It's the first time it is listed. It is listed 3 times, 19/2023, 59/2023, 6/10. I am asking you, have you filed a counter affidavit or not? Answer to the question, why you are saying something? Have you filed a counter or not? You don't want to file a counter. If you don't want to file a counter, I will take it as for granted that you have admitted the contentious reason that there is a willful default. I will impose the punishment. I'm passing an order of sentencing you. 3 times I have granted. Yes, the Learned Counsel appearing for the respondent has requested this court to grant time for filing of counter affidavit. When the matter was listed on 1/9/2023. No failing. Let him fail. No. Let him. That is a for granted those people. Let them file a count. 5,000 EM as advocate recognition. Yes. Yes, Indra. Yes, madam. Morning you made some request. Why? Anything survives in a contempt? Yes, it is a request of the Learned Counsel for the petitioner. List this case on 8/12/2023. Yes, call the next case. Yes, Mr. Lakshman Reddy. What is that petition? You are appearing for respondent in the very same case. You have complained the order. He is saying something.
Complaints must come time.
You are asking for complaints sometime. So what is the directions issued by this court? In these circumstances, this court allowed WP numbers also directing respondents to release the mortgage deeds executed by the petitioners therein after clearance of the loans. In terms of the said order dated also passing WP numbers. Says, what is your authority to withhold the documents? This is under the policy, purchase scheme policy. Yes, what is your authority? And the sale deed which has been executed earlier, see, there is a condition the moment the bank loan amount being discharged, you will become as an absolute owner of the property. And what is your right to withhold the documents under which provision of law you are entitled? Why you have not released? When this court passed an order? 5th day of January 2023, almost 10 months. So who is the competent authority in this case? Who is the third respondent? Who is the third respondent? Issue form 1 to the second respondent. Presently. Second respondent is Executive Director, Adilabad District Schedule case. Issue form 1 to the second respondent presently. Yes. List this case after 4 weeks. Presently, Prastaniki. Second respondent. Because the issue form 1 to second respondent only. Yes. What is the order's pathway? What is the direction issued? Read page 9, last paragraph, madam.
Yes, Lord.
Yes.
As soon after the company submitted by the police conducted inquiry into the content, in which revealed that the said company is not in nature and the reasonable time like the last day launch directed to publish the final.
See, in view of the above submission, the petition is disposal of directing respondent to furnish the copy of the final report to the petitioner to enable him to avail the remedies as available law. Yes.
they have not published any final report. Notice 18, dated 18/6/2023.
18? Read.
The request to the report subject cited, you have given a company.
Notice in page number. Read in it is there in Telugu. It is any difficulty for you to read the Telugu? Yes, read.
రెవెన్యూ రికార్డు మరియు తీసుకుని పరిశీలించగా ఇది భూమి రెవెన్యూ రికార్డు 1970 also సమాధి కూడా కట్టినారని విచారణలో తేలింది. ఈ భూమిలోకి మీరే అక్రమంగా ప్రవేశించి గుడి చుట్టూ ఉన్న లేచి 20 మందితో దౌర్జన్యం తొలగించాలని మా విచారణలో తేలింది. కావున మీరు ఇచ్చిన ఫిర్యాదు ఆధారంగా మేము ఫిర్యాదు.
What more you want? This is the report. Have you filed this report copy on the file of the court?
Yes.
Where you have stated in your affidavit? Yes. Now you serve a copy of the report to them. Final report, yes. Ready. Madam, unnecessarily you filed a writ petition at the first instance. There is a serious civil dispute between the two parties. You unnecessarily invited the finding now by the police. This finding is allowed. You lost your civil rights over the property. That is the reason why I am saying that don't invite the police into civil litigation. What is that they have stated? 1991లో చనిపోగా అతన్ని అదే భూమిలో పాతిపెట్టి సమాధి కూడా కట్టినారని తేలినది. That means they are giving a finding against you in their respondents. Advocates has to think over while by instituting the writ petitions whether it will be helpful to the petitioners or it will cause further damages to the petitioner. Yes. This court, while disposing the writ petition, directed the respondents. This court, while disposing the writ petition, you are appearing? Yes. What is your case?
26th of April, I responded to police station stating he made a comment on the Twitter platform stating that Lashman and Telangana state that it will show. Why did the government station will extend to about 140% shares? The news article had the photograph of Commissioner of State.
See, what is your grievance so far as this case is concerned? Your case is that the response.
I was part of the police station and made to sit there for 8 hours, which is a violation of our guidelines. Prima facie,
See, what is that evidence you have placed that the respondent police have called you to the police station? They confined hours together in the police station. No procedure has been followed except stating in affidavit. Have you enclosed any of the document in support of your contentions to the affidavit?
I had the final seeking videographs as well with Your Honor from the SHO. within 48 hours of my,
There are CCTVs. If they are illegally confined in the police station without following 41A or the guidelines issued by the Arnesh Kumar, those CCTV cameras discloses that they have not, without registration of the crime, you have been illegally confined.
I did file the RTI, Your Honor.
What happened?
However, I request the court to consider.
What happened to your RTI application?
They have not responded, Your Honor. And page number 23, Your Honor, they request you.
Yes.
The actual complaint given by the Inspector of the State Police Station after detaining me for 5 hours. Given I was in the custody by 4 p.m. itself, the complaint itself is received at 8 p.m. by their own admissions. And I was handed over for FIR copy around approximately 10:30 p.m., which is page 6 documented, page number 66, Your Honor. So that this is a
Page number?
Page 66 is the FIR.
Now they have registered an FIR against you. What is wrong in it?
Well, without a complaint, hours.
For what are the offences?
It's just the FIR that they filed against is 505 subsection 2, promoting religious animosity amongst the different groups of.
There's nothing wrong in it. They're confining you in the police station because your release would cause a lot of endanger to the public at large.
Okay, a comment on social media.
That is an offense being the social media only nowadays most dangerous than anything else.
Ingredients are required, Your Honor.
That we will examine. That we will examine. And pulini adi champoddu ani untadi. Wild animal has to be protected. And cheppi dan bayitichi pedthe andarini tintadi.
That's
Therefore it is confined.
Yeah, honestly, does not attract your.
It does not attract nothing else is there.
Basically,
You are unnecessarily since because you are enrolled as an advocate, you are contesting your own case, testing your ability in this contempt case. Test your abilities in a cases where there is no contempt at all. Contempt is a discretion. Contempt is a discretion of the court. It is not your choice to test your abilities or the knowledge. Where is the evidence? Show me the evidence.
Your Honor, I'm showing the evidence.
What is that evidence? You can't. Within 4 hours or 5 hours, they have registered a crime. There is no necessity that police should be given a priority to an advocate immediately when he went to the police station. There may be so many priorities to the police also. There are law and order problem. They have now registered a case against you on the very same date.
Yes, sir.
Then?
Detaining me without starting an investigation without an FIR itself is violation of section 154.
Criminal law can be set into motion by every person. Even police also entitled to sumo to take up the complaint. They are prima facie suspect you that giving a liberty or allowing you to move freely would cause endanger to the public at large or peace and tranquility. Therefore, they confine you in the police station. What is wrong in it?
Which is after recording the reasons, isn't it?
They will record the reasons immediately. How it is possible?
Only reason I was called.
This is like this. For example, somebody is met with an. It is like this, Mr. Counsel. Somebody is met with an accident. It is MLC. That is medical legal case. If you person body has been taken to the hospital, doctor says first you register FIR, then there must be some inquiry. Thereafter only I will treat you. That is like that only because giving liberty to you is endanger to the society at large. Therefore, they have confined. What is wrong in it? You are not doing any favor to the society. According to the police, you are causing harm to the society at large.
I mean, I'm sure they're
Because you are an advocate, I am directing them to file a counter affidavit. Reason is because he will get some fees, and police would realize that by virtue of the filing of counter affidavit, they will lose something. You file a counter affidavit and charge from your client, not free of service. When you have issued 41 notice?
I was forced to find.
Mr. Counsel, when the police came to know that you are an advocate, definitely they would give some respect or some type of, at least they will follow the procedure.
Yeah, I assure you I will put my case in the day of argument, Your Honor.
This is a contempt case. This is a contempt, Mr. Counsel.
I wrote my 5th semester exam, Your Honor, when they got me in the morning. I said I finished my exam and
Therefore, you are testing your ability now onwards. There are the advocates who are having 25 years experience being suffering in this profession.
But it was stopped without any reason and only because Commissioner of Police's photograph is mentioned in page number 15, Your Honor.
Page number?
He took my comment. Page number 13 is the article, Your Honor, in which Mr. C. Anand's photograph is mentioned. So
saying what? Saying what?
Saying my comment is in page number 15, Your Honor. I read it law and order.
No, what is that?
In Telangana, cannot do your job without being so insecure all the time. You should find another job.
What is the law and order?
It's just exam, not some work prohibitory orders to city. Since 144 section was issued at outside colleges, Your Honor, I have an opinion to state that outside colleges having curfew is unnecessary. Therefore, we said law and order.
It's better. It is better you reserve all your knowledge for the future practice.
No,
Don't waste your energy now itself.
There has to be an ingredient of law which I should have violated for an offense to be.
According to you, you have issued 41 notice on the same day. Why?
I have not been given a copy, Your Honor.
You are an advocate, you are a private, or you are studying law. Who forced you to sign the 41A? Would have been contested. If you have been illegally detained, you would have been filed another petition saying that your detention is illegal. Therefore, if I pay the compensation, follow Basu. There are so many cases in your favor. You would have been faced them. What past proceedings? After passing the proceedings, see, Mr. Counsel, if the police have invoked with a malafide intention, if they have registered any false cases, under IPC there is a provision for malafide prosecution. You are entitled to for malafide prosecution within a 1 year from the date of acquittal. You are entitled to prosecute the officers who have been registered as false cases, and also you are entitled to claim the damages under the IPC. There is a provision.
I have sought such prayers.
You have read IPC very thoroughly.
This is only exclusively for violation of punishment guidelines to have firstly initiated investigation without even an FIR. Filing an FIR after 4 hours and 4 officers, surrounding me. We all know the hospitality they confer.
File your counters. File your formal counter. Yes. It is the request of the learned counsel for respondent. List this case for filing counter affidavit. When you want, Mr. Venu, list this case on 8/12 because the police is now under the election duty. Yes.
Second number 60, Mr. Brahmeshwar.
Yes, who is appearing for the Brahmeshwar? Yes, madam. What is the order of this court? Yes. Yes. See, pending further orders, the respondents 1 to 5 and 8 are directed not to allow any illegal constructions to be carried out by respondents 6 and 7 without obtaining any sanction from the 5th respondent. According to the, you are appearing for? Gram Panchayat means which respondent you are appointing? Respondents 4 and 5 in contempt case. So then you have issued a notice to the other respondents. Have you filed your counter affidavit? What you have stated in your count? I will see whether it is required to be served on you or not. Yes, what you have stated in your counter affidavit? 5th respondent, Vishnu, you filed a counter affidavit. Telangana having temporary 5th respondent, Panchayat Secretary, yes. Yes, on 27/4. 29. Staying what? Read the Panchanama. Telugu Radha? Madam, Telugu Radha? చదవండి మరి. చెప్ప. Yes. Yes, what do you say, madam? They have conducted a Panchanama, they have recorded the statement of neighbors. According to them, no construction activity being allowed after the passing of orders by this court. If you want to remove the constructions which are in existence prior to granting of an order, you wait till the disposal of the writ petition, or else you go before a competent civil court to institute a suit for mandatory injunction of removal of all illegal constructions. I am closing the contempt now. నువ్వు కాబట్టి ఆ మాత్రమే చెప్తున్నామా, ఆయన మీ సీనియర్స్ ఆ మాత్రం కూడా చెప్పండి. Yes, Randy, this repetition, this contempt case has been filed for alleged violation of orders passed by this court in WP number 114. Yes, Abhibuddin. Yes, Abhibuddin. Who is appearing for the respondents? R1, RR124 notice served. Who is RR1? Yes, this court by order stated 6/10/2023 issued notice to the respondents. Mr. Notice issued by this respondent has been served on the respondents 124 in contempt case. Today, when the matter was taken up for hearing, there was no representation on behalf of the respondent in contempt case. Issue Form 1 to respondents. Have you not removed? Why? Why? What is the difficulty for removal of the encroachments on the road? I said, in view of the above submission, fourth respondent is directed to remove the illegal restrictions, encroachments on the public roads after following the due process of law. Yes. This is order dated 20th April 2000. Now almost all 6 months is over, Mr. Ramon Reddy. So, sir, form an issue, yes, let him come and explain. Why you are? If this court exercises its discretion under the provisions of 1971 Contempt of Courts Act, then only the bar at large will be respected by the officers as well as other citizens. కానీ వచ్చి చెప్పుకుంటాడు వాడు నీకెందుకు పాతం దగ్గర కొత్త దగ్గర పాతం దగ్గర కొత్త దగ్గర ఇద్దరి దగ్గర ఫీజు తీసుకో రామ్మోహన్ రెడ్డి ఇట్ ఈస్ ఇన్ ఆర్ట్ కలెక్షన్ ఆఫ్ ఫీజ్ ఇస్ ఇన్ ఆర్ట్ పాతం దగ్గర తీసుకొని మీద కంటెంప్ట్ ఉందని కొత్త దగ్గర తీసుకొని నువ్వు ఇంప్లీడ్ అయినావని అయిపోయా ఇట్ ఈస్ యువర్ చాయిస్ you don't have any business except appearing before this court in contempt cases. He said the request of the Learned Council for the respondent for filing counter affidavit. List this case on 1/12/2023. Because elections are there. I am posting after elections 8/12/2020. Yes. Yes. Who is appearing for the petitioner? Yes, madam.
This case is filed for the willful disobedience of the order of this Honorable Court in IA number 1 of 2023 in writ petition 27539 of 2023, my lord. Order is at page number 14.
Yes, read the relevant portion of order. Read the relevant portion of order.
Yes, my lord. In the writ petition is filed for the set asiding of the proceedings by the respondent number 1, my lord, giving permission to the district collector to alienate the property, and the same is set aside, my lord. It is at page number 15.
You have the
In
same.
same, there shall be interim suspension of the proceedings dated so and so.
According to after even interim suspension, also the collector has issued any proceedings.
Yes, my lord. In page number 29, they have even demolished my compound wall, my lord. The portion of my compound wall, page number 29.
You forget about demolition of your compound wall. Is there any proceedings being issued by the collector?
No, my lord, no.
Then how can you say that they have violated this order?
But unless the only with the implementation of the order suspended by the Honorable Court.
Madam, allotment of land in favor of the Dargah Waqf Board was the subject matter of the writ petition. That is the case.
No, my lord. The issue is actually 33 acres of the land has been earlier allotted to the petitioner society, my lord. After 40 years of that allotment, upon the request by the district collector, the respondent number 1 in the petition has given no objection for alienation of such land. That letter issued by the respondent number 1 was the subject matter of the writ petition, my lord.
That was suspended. How it amounts to contempt? How it amounts to contempt? Demolition of the compound wall, how it amounts to contempt? If they are demolishing illegally, proceeding with your property, you are entitled to file a separate writ petition. How it amounts to contempt, madam?
Unless this order, this letter issued by the respondent number 1.
Madam, I followed how many times you want to say. See, the proceedings have been initiated by the collector, giving no objection for allotment of the land earlier allotted to the society. That proceedings have been challenged before this court has been suspended, and subsequently, if they demolished your compound wall, it is a separate cause of action. You have to file a writ petition questioning their illegal demolition without issuing any notice. How it will be helpful for you for filing of contempt case? That is only your case.
Only the letter which is suspended by this honorable court only will give power to them to enter into my premises, my lord.
I don't know whether you are in a possession or enjoying the property, or
I am in the position that
Madam, if they are illegally entered into your premises, you file a suit for damages.
my lord, may I make a submission? May I make
Madam, the order is suspension of the giving a consent by the district collector for allotment of the land which has been earlier allotted to you. Subsequently, if he has issued any proceedings allotting this land to the in favor of any of the other person, yes, there is a contempt. If you demolished your construction of the compound wall, whether you are legally constructed or illegally constructed, I don't know all those things. How it amounts to contempt?
My lord, the letter is not issued by the district collector earlier, my lord. The letter is issued by the respondent number 1, that is Special Chief Secretary, Animal Husbandry and Dairy Development. He has issued no objection
for filing counter to list this case on 15/12. Yes. Let them file counter, it will examine. Yes. 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 Anything survives. What is the orders being granted by this court? Yes, what is their stand now in counter affidavit?
Even after the passing the order, not respond before. Consider the illegal construction.
Yes, what do you say, madam? Page number? Yes, read the relevant portion.
They have visited the site and saw the construction was built in 2020. They want to respond to COVID. Want to proceed with any type of construction work. Relation project. We have seized the premises, your lordship.
You have seized the premises also. Then what remains? What more you expect from the municipal corporation, Mr. Rao? Page number? Is the property still in custody of the municipal corporation? They have also erected the board saying that this building is seized under section 460. What more you want?
They are not the illegal construction.
Whatever may be, now the construction being seized, subject to, I will give a liberty to state all your claims in the petition in view of. I am here to take care of you, Venkatragaramlu. Why you are bothering? Except you say that you have to receive some certain fees from your client. That is only the like that. See, they have filed a photograph saying that they have already They have filed a photograph saying that they have seized the property. What more you want? When the property was in the custody of the municipal corporation under section 461A of the according to you, they filed a false affidavit before this court. Yes, at the request of the land council for the petitioner, list this case on 24/11. Yes. Yes, what is the matter, Mr. Council? Governor Peter? What is the directions issued by this court? Not to interfere with the civil rights of the petitioner in any manner except in accordance with law. If the presence of the petitioner is required for investigation, the respondent and police are directed to follow the procedure. Yes, what is the allegations in this contempt case? Read the allegations in the contempt case. It is the case of the petitioner that at the instance of the police, the compound wall has been demolished. You have supervised the constructions being demolished. In Hyderabad city, there is no other business to the police except to interfere with the civil disputes. And your postings are only for that purpose, for settlements. Who lodged a complaint? Yes. What is that action you have taken? Yes, what do you see? There is a pen. You have encroaching government land and proceeding with the construction of raising of compound wall. Therefore, on the complaint submitted by the HMDA, they have proceeded to register the case and they have taken according to law only. How it amounts to illegal? He is not well. Yes. At the request of the Land Council for the petition. Submitted that the Land Council appearing not doing well. This case on 15/12/2020. Mr. Kodeshwar Prasad.
Please, Lordship.
Yes, Kodeshwar Prasad.
Your Lordship, page 6, Milord, order directing to conclude the investigation within 4 months, Milord.
Yes.
So far, Milord, no action has been, Milord.
What is
Final report has been placed.
You have also filed final report.
Not filed.
When you have filed? 19? Why you have not filed a copy of the final report to the petitioner? Unnecessarily, why you invite the contempt case? Contempt case is filed on 16/10/2023.
Yes, sir.
Then according to you, when you filed final report? 19/5/2020. 26/5/2023.
Yes.
That means after filing a final report, he filed a contempt case.
Yeah. For this, Milord, I need some clarification. Lordship, as per the CRPC, I am entitled for notice when the matter is closed or, Milord, for whatever the final report, I am entitled for notice. Kindly direct them to file counter, Milord, along with the, Milord, the report and the notice filed along with the, Milord. I am entitled for notice being a complainant. Direct them to produce the same, Milord.
CRPC. Under which provision of law?
Yes, from CRPC, Milord. When the complaint.
CRPC only, and the CRPC on which section says?
91, Milord. Right
91
now.
is only a notice.
Notice. The complainant is entitled for a notice when his complaint is closed. Otherwise, even magistrate will refuse to receive the report also. That is the primary duty, Milord, of the officer.
This court directed them to file a final report. According to the counter affidavit filed by the respondent, they filed a final report. This court is not concerned in a contempt case whether the final report is with regard to closure of your case or not. This court is whether they have filed a final report on the file of the concerned magistrate or not is the issue. He says the final report has been filed on 26/5/2023. You says before filing final report, a notice has to be served. Show me the provision. Show me the provision under section.
Yes.
Procedure code.
CRPC, Milord, I will produce.
CRPC only 173 relating to filing a final report.
Final report. I am
173. What is that supply of copy? 207. Come to the page, section 207. Read section 207.
Yes. No, Millard. Right now, it is the.
పోలీసులు వెనక పడతావు నీకు సెక్షన్ తెలియకపోతే ఇట్లా చెప్పు కొటేషన్
No, number of criminal cases, even
అందుకనే చెప్తున్నా పొద్దుగా ఇస్తే పోలీసులు వెనక పడతావని. ఏమైంది? రీడ్ సెక్షన్ 207.
Yes, Millard. I am entitled for notice. They have not served the notice, Millard.
Instituted on police report. The magistrate shall without delay furnish to the accused free of cost copy of each of the following.
Yes.
Read. In any case where the proceedings has been instituted on a police report, the magistrate shall without any delay furnish to the accused free of cost a copy of each of the following. That is the police report. That is the charge sheet which has been filed or final report. Therefore, you make an application on the file of the concerned magistrate under section 207 CRPC. He will furnish all the documents whatever required for you.
That is
Read
why,
section 207. అరే చదువు నువ్వు చదువు అన్ని పుస్తకాలు పెట్టినా వెనక అందరికి కనబడుతుంది చదువు 207.
no, Millard. I will go through, Millard. My humble submission is I have not received any report.
Leisurely, there is no problem. In other case, we will test whether you are right or not. This repetition has been filed. This contempt case has been filed.
May I request one small adjournment, Millard? I will go through and.
అంతా అయిన తర్వాత అడ్జమెంట్ చేస్తే బాగుండదు.
No. Let me clarify, Millard. I don't want tomorrow or day after tomorrow. I will check and I will come back to your lordship.
అయిన తర్వాత అటు ఇటు తేల్చేయాలి. అది ఇద్దరికి మంచిది. Yes, this contempt case is filed.
There is no
Contempt case is filed for alleged violation of the orders passed in WP number 14684 of 2023, dated 13th June 2023. Mr. This court, while disposing of this petition, directed the second respondent to complete the investigation and take the charge sheet in crime number 7 of 2023 of Borivali Police Station as expeditiously as possible, preferably within a period of 4 months from the date of receipt of copy of this order. Mr. Urging non-compliance of the contending that the respondent police have not filed the charge sheet or final report within the time specified by this court, this present contempt case has been filed. A counter affidavit filed.
Not filed, Millard. That is what.
Person be there any case counter in the case. The government Peter appearing for the respondent. The respondent has submitted that soon after receipt of the orders from this court, the respondents have concluded the investigation and also filed a final report. The file of the concerned magistrate on 26/5/2023. In view of filing final report, terms of the orders of this court, there is no willful, deliberate disobedience on the part of the respondents in complying the orders of this court. Accordingly, the contempt case is closed as no orders are necessary. Yes. మంచి కేసులో చూడు. Yes.
At least I would have knowledge, Millard. I don't.
చదువు అది సెక్షన్ 207 చదువు ఒకసారి. Yes. Yes. No question. Contempt. No senior, junior. Contempt is it is a violation of the court order. What? See, it is for me to take care. What is the directions issued by this court? Meanwhile, the respondents 2 and 3 are directed not to allow any illegal or unauthorized constructions being carried on by the respondent number 4 in the absence of any sanction plan. Yes, what do you say in the counter affidavit? Yes, read. See, what do you say with regard to ongoing constructions? See, read last paragraph. Old construction and there is no ongoing construction over this house property after passing of the imprimatur stated zones. It is submitted in view of the above observation. There is no ongoing construction undertaken by the said. Yes, you contest in the main writ petition. Nothing else is there in the contempt. Yes, right.
The order was passed in April.
You hesitate in the pending writ petition. Yes, right.
Even then, it would be.
Yes, specifically Mr. Counsel, you read the paragraph 4, last 4 lines, wherein specifically stated earlier during the period of Gram Panchayat was in existence, a old house has been constructed and subsequently it was renovated even before the Gram Panchayat merged into the municipal corporation. And your contention is that he is proceeding with the old constructions by renovating the said constructions without obtaining necessary permission from the municipal corporation. Therefore, it amounts to contempt. They are saying that there is no ongoing construction over the old construction for which the Gram Panchayat is also allotted the house number. The municipal corporation only has given a re-house number, re-number to the existing structure. If it is in a totally illegal construction, after disposal of the petition, you file a fresh contempt case. Yes, Randy. Who is your senior? Who is your senior? ఏం లేదా సీనియర్ అయినా జూనియర్ అయినా వేస్ట్ అని వస్తుంది. Yes. And it is for me to take care of what is your role so far as the contempt is concerned. It is violation of the court order. I have to take cognizance of the contempt. Yes, Nani. Yes, Yes. What is the matter?
Giving protection to the unofficial constructs, compound, who seeks are trying to hand out the position of the taking position from the petitioners. The lordship in this matter, petitioners having a injunction order and police protection also. Even in spite of that, your lordship, police registered.
Yes, file your counter affidavit. Yes, at the request of the Learned Counsel for the respondents for filing counter affidavit. List this case on 8/12/2023. Yes.
So now, already.
Yes.
Your Lordship, resolution number 1.
Yes. Yes.
Your Lordship, may have it next Friday, Your Lordship.
You take up for hearing. Yes. Why the revision is listed before me? Surya Pet. Yes. Interim orders granted earlier is extended.
Earlier, they shorter date.
No, at 2 weeks because there is an election. All police officers have been involved in a
These police officers are in the site.
no, in entire Telangana,
In the site.
whatever may be,
So some also.
since earlier case of 2 weeks and I am a counter. Date 2 weeks. 112 and better. Yes. This we will hear for final hearing if there are only formal parties remaining respondents. We will hear the main case. Yes. This the interim orders granted earlier is not list this case on 1/12/2023. Interim orders granted earlier until interim orders granted earlier extended till then. Posted for hearing. Yes. Posted
71.
Posted CRP for hearing. Yes.
So at least extend till then.
Yes, till then only. Yes. Who is your senior? Item 71, yes. ఇక్కడనే ఎక్కడ ఉంటాడు పిలువు గట్టిగా ఒకసారి రీచ్ అయిందని ఉరికేస్తాడు ప్లీజ్ నాట్ వెల్ యూ ఆర్గ్యూ ది మ్యాటర్ వాట్ ఈస్ ది రిప్రజెంటింగ్ వాట్ ఈస్ ది మ్యాటర్ యూ టెల్ మీ I will direct them not to interfere with the civil disputes. What more you want? Excess offense. Yes, what is their case? Not to interfere with the business. Em dukanam nadipistunnam kal dukanama. What is that business you are running? When there are the respondents are under the law, they are entitled to authorized by law to inspect your shop. You are running A4 shop, you have to maintain the stock register. Every day excise sub inspector has to sign the stock position. Owner, right? I will direct the respondent 7 not to interfere by, I will allow the excise authorities to interfere with your business. ఇవన్నీ చెప్పొద్దు నాకు అది తెలియదు అనుకుంటున్నా ఎక్సైజ్ బిజినెస్ అంటే మాకు కూడా ఉండే వైన్ షాప్ గోదావరి కింద 1998లో నాకు అన్ని తెలుసు there is a stock position register would be maintained by the excise authorities. Then the relevant point of time, the licenses would be called as a Form 17, Form 18, Form 21. దాని కింద every day excise inspector has to sign the stock position. వెళ్ళైంది let your senior may come tomorrow. We'll have, yes. Next week. I'm posting next week. Yes. At the request of the Leonard Council. When do you want? Is this case on 17/11? Yes. Yes. You filed an extension petition. Yes, interim orders granted earlier. The IA number 3 of 2023. Event, sir. Counter affidavits have been filed.
Number 84, you
You wait. Let me pass an order in this so far as item number 92 is concerned. No counter affidavit has been filed. Notices have been served. Yes, interim orders granted earlier. The IA 3 of 2023 filed seeking extension of interim orders is allowed. The interim orders granted on 6/10/2023 is extended until further orders. Yes. List this case on 8/12. Yes.
98.
Yes.
Yes.
Oh, what is your case? Tell me.
They are not registered.
Yes, what do you say? Huh? Have you registered or not? Why? Still, there no instructions have been issued. I will direct the concerned officer to be present. Yes.
Flagship item number.
You wait. Yes. The land ground feeder appearing for the respondent 6. Time to get instructions. Earlier on 2 occasions, this court granted time for the land ground feeder for getting instructions. Mr. In view of not furnishing instructions by the each respondent. In view of not furnishing instructions by the respondent number 5. But then, in view of this issue, the respondent 5 shall appear and explain the delay in furnishing the instructions. The government freedom. Yes. Yes, list this case 8/12 after elections. Yes.
The honorable court has asked them to file a proof of something. So we didn't include any additional documents or lordship to filing.
Item
84 your lordship.
84 is the petitioner counsel is Rapur Bhaskar.
And respondent 7 year.
Then why you are bothering whenever it is this? Have you filed any wakalat?
Yeah, we filed a wakalat.
Where is your name in the cause list?
Bunty Chandrasekhar.
Where is why your name is not printed in the cause list? Item 85, that is not 85. 84 is the Rapur Bhaskar. Item 85 is yours. Bunty Chandrasekhar, respondent number 7. Both the cases you are appearing.
83 and 84.
It is connected.
But both are filed
It is connected.
in the same cause of action. Your lordship.
84, 85 అనుసరికి చదువు లిస్ట్ ముందర పెట్టుకో ఏదో పెద్ద బ్యాగ్ పట్టుకొచ్చి నువ్వు పాస్వర్డ్ వచ్చినట్టు కానీ లిస్ట్ పెట్టుకోలే. See, item 84 and 85 are connected. Both the cases have been filed by Rapur Bhaskar.
Yes, sir.
And in item 85, you filed a wakalat for R7.
Yes.
Therefore, now you want time.
No, we want a document. We are ready to file a.
నన్ను ఎందుకు అడుగుతున్నావు ఆ డాక్యుమెంట్ నేను ఎడికెళ్ళి ఇచ్చేయాలి? When you file, you know the procedure of the writ proceedings rules. When you file a wakalat for appearing for the respondent, you are entitled for copy of all the copies from the registry. Go and collect from the registry, not from the court. Yes. Or else request your colleague friend to serve set of papers. That is the procedure. Why you are making a representation to me? Yes. Somebody is here, Rapur Bhaskar. Serve copies on other side. Why? What is the difficulty for you to serving a copy? Yes. Serve set of copies. Yes, Mr. Jagan. Yes, what is the matter?
The police without any authority straight away attends a written with the bank.
Yes, who is appearing in item 104? Yes, GP Home. Yes, who is appearing? What is that similar order, sir? First 102. That is after filing of counter affidavit. That is after filing of counter affidavit. See, the police, as and when they suspect commission of offence, they are entitled to issue a notice under section 102 CRPC for the concerned banker to freeze the accounts after intimation to the concerned magistrate. That is your case. According to you, no notice has been issued, no procedure has been followed under section 102, and the property which has been seized by you is a bank account, is not the suspicion account in pursuance of criminal proceedings. That is your case. What do you say? Yes, list this case for filing counter affidavit at 1711. Finally. They are asking for 1 week. What is the purpose of listing and yes. 1 week only I am granting. List this case on 15. Yes. File it on 15. See, his bank account is very much necessary for everybody. 15?
It is on 17. It is 2 days delay.
Government feeder. If somebody's account being freezed, see, how can he transact his money? He has to spend everyday expenditure from the drawing amounts from the bank account. You are also having bank account for deposit of the salary. Your account being attached, what will happen? Tell me. ఇంటికి సాయంత్రం పోదా అని చెప్తావు పిల్లలకు ఓట్లు కూడా తీసుకొస్తా ఉంటావు సడన్ నాడు ఎవరు నీ అకౌంట్ అటాచ్మెంట్ అవుతుంది ఏం చేస్తావు చెప్పు ఊకోని మళ్ళీ ఇంటికాడ నీకు తెలుసు కదా ఫైల్ ఇట్ అండ్ 16. Yes. Yes, what is that plan? It is already there in the list. What is that you want? Yes, list this case for filing of counter affidavit. List this case for hearing after filing of counter affidavits. Yes. They will file it. 1.5 months is not a delay. There are 10.5 years where the counter affidavits have not been filed. If you wear the gown, and you will realize what is the difficulty of the counsels for getting counters being filed by the respondents. Let it be there in the list itself. There is no mention. Yes. Yes.
Lordship, item number 107, Lordship.
Yes.
Lordship, the petitioner is suffering with the back pain in the central jail, Charlapalli, Lordship. So we have filed IA2 seeking interim bail, Lordship. Already I have enclosed the discharge summary also. So kindly consider this case, Lordship.
This can be listed on Monday. You get instructions so far as the item 107 is concerned.
Highly obliged, Lordship.
This case on 17. Yes. 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 What is that? All the cases will be taken up on Monday. Why? Yes.